During these unprecedented times, CBIA is finding new ways to enhance your benefits package without affecting your bottom line. CBIA's home and auto insurance program is an additional benefit of your membership, requiring no additional dues dollars. There's also no administrative work and no payroll deduction, making it fast and easy to provide open enrollment options for new employees and new hire packages. CBIA offers discounted rates that aren't available to just any agent. We work with some of the top insurance carriers in the industry, all rated A or better by AM Best. While tailoring coverage to an employee's needs, our licensed professionals will check coverages that they have currently and close any gaps that exist. We also offer more than just home and auto insurance. We can provide coverage for all personal lines, including renter's insurance, condo coverage, and specialty coverage for RVs, boats, and any other valuables. To get started, contact Ruth Galinsky at CBIA.
I consider them my partner. You know, that's really that's how I feel about CBIA. My name is Cynthia Ambrose, and I'm the Human Resources Manager for Integrated Physicians Management Services. We're located here in East Hartford on the river. The bulk of what we do on a day-to-day basis is medical billing. We also are experts with compliance. So we've been working with CBIA since the beginning of my tenure with this company, which is 31 years. I call CBIA generally for employment law related questions or benefits. I find that I pick up the phone quite a bit.
Good morning, everyone. Happy Wednesday morning, May 19th, 2021. And welcome to CBIA's half-day webinar on navigating the employee leave maze. We're glad you joined us. I'm Diane Mokrisky, HR and Employment Law Counsel here at CBIA, the Connecticut Business and Industry Association. I've probably spoken to many of you on the phone, whether you've called me directly or used our HR hotline. Hopefully, as Connecticut more fully reopens with decreasing COVID numbers, I'll get to meet some of you in person. So one issue I do get a lot of calls about is employee leaves of absence. So today, we're going to be talking about all the various reasons why an employee may need to take leave away from work and what the employer's legal obligations may be in response. Not the sexiest problem that HR managers and business owners face, but nevertheless a very common one, and one that we all need to master. This was a complicated issue even before the pandemic. The interplay between workers' compensation, family and medical leave, disability leave, maternity leave, paid sick leave. This has always been a frustrating and confusing maze of state and federal laws. Now, with the pandemic thrown into the mix, it's only become more complex. For example, when a COVID-positive employee exposes colleagues at work, is that a workers' compensation issue? What about side effects from the vaccine? If the employer was the one who insisted on it, does the employer workers' comp carrier have to pay for it? What about remote work? Does an employer have to worry about injuries incurred while employees are working from home? For family leave, do you understand the differences between federal FMLA, Connecticut's paid FMLA, and the emergency FMLA enacted in response to the pandemic? What about disability leave? When an employee has long-term effects from COVID, in other words, the long haulers who suffer symptoms for months at a time, do they have disabilities that have to be accommodated with a job-protected leave of absence? And is there such a thing as leave from the physical workplace as opposed to leave from work as a whole? So these are just a few examples of the types of questions we'll answer today. We're going to talk about leaves of absence both in the traditional sense and the ways in which the pandemic has impacted those traditional rules. The webinar will focus on 4 distinct topics, but you'll see quite clearly that the topics actually connect with and overlap with each other. And that overlap is important. For the first hour, we'll discuss workers' compensation issues. After a break, we'll tackle federal FMLA and Connecticut's paid FMLA and how those two laws interact and overlap. We'll take a second break, during which you should really grab some coffee or some fresh air if you can and clear the brain, because the third session is pure alphabet soup. We're going to discuss the relationship between FMLA, PFMLA, EFMLA, ADA, and maybe even a little PDA, because what's a leave webinar without some talk about pregnant people, right? And then finally, we're going to take a break from the acronyms and focus on a different type of leave, and that's the partial leave or reduction of hours that's implicated when an employer applies for the shared work program. This has been a hugely successful program, particularly during the pandemic, as it provides an alternative to layoffs. So we're due to finish by about 12:30 today. If you have any questions at any point throughout the program, we do want to hear them. So you can submit them through the Q&A function on your screen, and you'll press the Ask button. Please be aware that you can communicate with us and with each other through the chat function, but we'll only address questions that come in through Q&A. So again, press the Ask button. We'll be collecting and then turning to those questions primarily at the end of each individual presentation. So we've got a lot to get to, so let's jump in with our first speaker, Attorney John Letizia, who will be discussing workers' compensation issues. Attorney Letizia is the managing and founding partner of his firm, Letizia, Ambrose & Falls in New Haven. His work includes employment law, healthcare and corporate counseling, mergers and affiliations, litigation defense, and labor negotiations. He represents his clients before courts and administrative agencies like OSHA, the Department of Labor, the EEOC, the NLRB, and of course, the Workers' Compensation Commission. John, good morning. Thanks very much for being here.
Thank you, Diane. Today, my topic is related to employment and workers' comp and everything surrounding COVID, from a belief or fear of having COVID, being exposed to it, to having COVID, to the vaccine. And I'll also interject, along with my outline, the various issues related to a leave. One of the fallacies or mistakes that exists is most employers believe that if someone is hurt, they get a workers' compensation leave. There is no such legal leave. And so many employers also believe they have to continue the person on this mysterious workers' comp leave for 6 months, for a year, for 2 years. I've gotten calls from employers talking about people who have been out of work for over 2 years. They're holding the position open, they're providing benefits, and in one of my clients, the workers' comp absence gets 56 weeks paid benefits because they accrue 4 weeks to 8 weeks, so it could be 60 PTO time each year they're out. So please use the Q&A to ask any questions related to that, and I'll try to touch on it throughout this program that I'm doing. We're going to touch on the 9 topics above, and I'm also going to interject because the toughest legal issues I'm addressing is someone who has what we call in the industry a psych overlay sometimes. So they may have a minor side effect from a vaccine, yet psychologically they believe it's significant. I know one person who actually was rushed to the hospital believing they were dying because they got the vaccine. And, and his professional, when he went to the hospital, there was nothing wrong with him other than the typical side effects of the second dose at times. But is that workers' comp? And we'll touch on all of these topics, and let's start with what an employer can do. We're so used to hearing in Connecticut, and if you do employment work in the EEOC or the Commission on Human Rights, everything you cannot do, that we're just assuming you're limited. But one thing I've been advising employers as we remained open is there are many exceptions to these prohibitions because of the pandemic. And do not forget that. You know, these are unique times. I know we all understand that. But also you have more flexibility to ask certain questions and follow-up that maybe would not have existed just a year and a half ago, especially when it relates to the health and safety of employees, customers, and clients. Always remember that, because that's going to be a basis for you to do quite a bit that you may otherwise not been able to do before this pandemic and these measures went into place. Let's start with the EEOC. Basically, in December, they came out with guidance stating you essentially could require everyone to be vaccinated. I still get that question. But there are exceptions. Well, the number one exception is it's a work condition, so if you have a union, you need to negotiate that with union employees. But the listed exceptions, which tend to be subject to abuse and misunderstanding, is if the employee declines because of a linked disability. And I tend to be very skeptical about this exception, and I tell you some of the stories I've gotten from clients and letters they've gotten or medical notes they've gotten. I basically consider it, if the employee says, well, I'm not getting the vaccine because of my allergies, I say, hand me the EpiPen. And if they don't hand you the EpiPen, I'm going to get skeptical. Ironically, I think the best medical basis for denying it, I haven't had this come up yet with a client, is if someone went to the psychiatrist and said, I'm afraid, because that's a linked reason. I hope I haven't given anybody ideas, but that's the one that would be arguably a difficult one to say I'm not accepting it. We've seen clients who've gotten notes that said, someday I plan on being pregnant, so I do not want the vaccine. Well, that just contradicts the benefits of the vaccine if you are pregnant. And so we'll touch on some of that, and we'll also touch on if the employee refuses to return to work or refuses to be vaccinated, what you can do. And the second exception is sincerely held religious belief. I added the word sincerely because we don't want people to all of a sudden find their version of God or religion to avoid the vaccine. And I'll give you stories that are coming out of the woodwork. And I'm not talking about people who have always been your problematic employees, the ones you've already red flagged that look for some excuse for every reason to complain about everything. I'm talking about the much more difficult cases that I haven't faced in 33 years of an otherwise excellent employee who seems to be making shockingly unreasonable statements or accusations. And how do we deal with that? Well, it's a balancing act. I tell everyone I became a much better employment lawyer when I, left a big firm and started my own small business. Well, I have 25 employees. I deal with the workers' comp costs, the unemployment costs, and so on. So I understand what many of you are facing. It's not so easy to say, if you're not vaccinated, leave, and then you have no one to replace your IT person. The EEOC guidelines do not distinguish between healthcare and non-healthcare, so they're very beneficial in that way. That you could, the easiest no-brainer for me, and easily to defend with Commission on Human Rights, before a court, before DOL, and so on, is the employee who has direct customer, client, patient contact. You have an overriding obligation pre-pandemic to make certain you're not doing a number of things, and we'll get into the OSHA one soon, but you're not putting your patients, client, customers at risk. With anything you do, whether they come into a lobby with a slippery floor that you didn't have a sign for, whether you have an unsafe HVAC system that's spreading the flu, and so on. Well, what's more pressing than all of those? Well, COVID causes death. And it's just baffling to me that, people this day don't understand that you have an overriding obligation. I'm talking to people about certain employees to make certain you're not putting them at risk or anyone else at risk. So requiring the vaccine is something you could do. Then there's these positions, especially of direct, we'll call it customer contact. The second one is incidental contact. You know, I consider these important positions as well. Well, that person, she's in the stockroom. Well, does she deliver the box out to the car? Well, then she has customer contact. Well, that's an office person. Well, if someone has a return, does she interact with them? Well, yes, she does. That's customer contact. In my mind, non-customer contact is the person working remotely, and that's probably the toughest one to say you would like them vaccinated. But we could talk about remote work. Some of you may remember I've spoken on that, and it's another interesting topic. You know, we expect the EEC or Commission to take the position. I always am skeptical that they're always going to be pro-employee, that the employee is allowed to refuse it based on the ADA or the religious right to freedom from discrimination due to religion. Well, in the case of the disability, you could require sufficient acceptable proof from a treater. My clients are getting these letters where these people are going into these clinics or docs in the box, I call them, for $135. Rarely is an MD writing these notes. It's an APRN or PA stating so-and-so, because of, you know, her physical issues, doesn't need to be vaccinated. Well, remember I talked about waiver of certain requirements or prohibitions? This is one of them. You could require more specific information as to how their physical condition is linked to the danger of getting what might be the world's safest vaccine in history. Go get the flu shot and see how many people still get sick from that or the flu. So don't simply accept any note and believe, oh, well, John, you know, HIPAA prevents me. I love when people cite HIPAA. HIPAA is a federal law that is limited in its application to healthcare providers, insurance people. Connecticut law prevents you from many situations doing this, but not HIPAA. But you have a right to inquire for more specific reasons linking the alleged condition, disability, or illness to why they cannot be vaccinated. The religious belief is very interesting because many people follow the Christian Scientists who are generally against vaccinations. Well, that's not true. They, as a rule, frown upon it, but specifically they leave it up to the individual. And that's the same with the Dutch Reformed Church, which also generally has a label of being anti-vaccines. And on the Connecticut level, the Christian Scientist leader in the Connecticut came out and said that in writing because no one was believing them. And on a national level, they've come out and said it's up to the individual. If someone gets vaccinated, they are in no way punished by the church or excommunicated. And for those who follow the Catholic religion, Pope Francis has said it's a moral obligation to be vaccinated. So again, you know, be hesitant on some of these reasons. We had one client who the person came in and actually said, I follow the divine God religion. And when asked to define that, they basically said, well, it's a religion that I am God and I will not poison my body. But then we said, fine, okay, provide us a citation, provide us a scripture, provide us something from your pastor, which I guess would be yourself. And they could not. And then the real truth was they just didn't want to be vaccinated. So if not for this HR director asking more questions, everyone else in this office would have believed that this employer was forcing this person to violate a religion when it was not a recognized religion. And it turns out that was not the case in that person's situation. But I get nervous because some of you may be familiar with Universal Life Church. My son, sophomore, decided that he was going to marry people, so sent in his $75 and now is a pastor of the Universal Life Church and could marry people in his dorm room. Hasn't done it yet, thank God. But in these situations, don't be afraid to ask for support and follow-up, because what we're going to lose sight of, and I may go back, is look at D. People forget this all the time, and I do quite a bit of employment-related workers' comp, and they'll sit there and say to me, John, so-and-so is totally disabled from work, up until yesterday when I told him his 1 year leave that we gave him for workers' comp accidents expires and he's laid off, then he goes back to the same doctor in a physical position, manual labor position, gets a full release. Well, I just love those. God forbid that doctor ever gets arrested for workers' comp fraud. And in that situation, could I take him back? The answer is no. Well, what basis? Well, you should get him examined, but you have an overriding obligation in that workplace to make sure it's safe. OSHA has hundreds of thousands of specific regulations, directives, and guidelines, whether it be paint, whether it be HVAC-borne pathogens, and so on. But at the end of it, they said, just in case we didn't cover yours, it's the general duty clause that every employer has an obligation to every day ensure a safe workplace. Are you ensuring a safe workplace if you're routinely allowing people to go unvaccinated? My answer is no. Let them file the lawsuit, let them file the complaint, and my defense is, well, I will not put any employee, customer, vendor, or guest at risk of dying, because that's what we're talking about here. And that employee who chose not to be vaccinated, who may contract the virus and give it to someone else, who is hospitalized or dies because of comorbidity issues, is not going to be paying for that lawsuit or that funeral. So, I think you're on very strong ground. And again, remember, there are exceptions if it's a union contract. There are exceptions for religion and disability that we talked about. But, just going back for a second, again, you could require acceptable proof in writing, whether it be, something from their pastor, whether it be from a treater, and it needs to link that. I hit the wrong button, even though this is dummy proof. The accommodations, too, I love this. Well, whether it be someone who is not going to be vaccinated, they say, well, I can work remotely. Well, no, you can't. The reasonable, it's your choice, even if it's deemed a reasonable accommodation of someone, whether it be workers' comp or whether it be someone you require to be vaccinated, you just simply lay them off in many situations, or whether it be someone who's has long hauler effects, which is very serious, very, very serious, of the virus. Well, many people forget this, but it's a temporary accommodation, so it doesn't have to be made permanent, and that's very clear under the ADA and Connecticut law. And you determine the reasonable accommodation. The employee doesn't get to pick and choose that accommodation. The EEOC goes on further on this issue that's coming up now. Well, I hear getting a lot of questions. Could I ask them for proof that they've been fully vaccinated? And the answer is absolutely. Again, just keep remembering, you have an obligation to ensure in every reasonable means possible you have a safe workplace. And requiring them to show you this card, which is easily obtained on eBay, by the way, if you'd like extras, is that requirement. Questioning the validity of the card is acceptable. Okay, you said you got this at CVS. I don't believe you. It looks like somebody wrote over something here or erased something. Let's go to pull up from CVS on your website, on your app, or go to the store and get me copies of when you had the vaccine. Well, I'm not doing that. Well, then you're not coming to work. Or we're not accepting this and you'll need to wear double masks. You require double masks. There's no rule. It's one mask only. So what people are misunderstanding is there's tremendous flexibility that we're not used to under the ADA guidelines or otherwise to allow for these second level of inquiries, to allow for these questioning of these COVID cards. I just hope someday they'll come up with a little something better. The state should be able to make money off of this with a COVID card. Another issue's come up, and it got quite a bit of fanfare last year, was if someone contracts COVID at work, is it a work-related comp injury? And the answer is yes. It's very basic. But that question is not so simple. we've been dealing with employees that are claiming they got it from work when we find out that their spouse has it at home and their adult children have it at home. Well, those things, again, it's not automatic that it's covered under workers' comp simply because someone else in the office had COVID. You know, if you're following all the measures, you would have shut down, isolated, sent people home as we did. I'm very proud that we never closed and we have never had anyone spread the virus at the office because we immediately isolate, separate, and send home. So there are issues here with workers' comp where it's not simply, oh, they have COVID. We had someone else in a different department who had COVID. They claim they met that person in the men's room while getting a soda, so it's probably work-related. Have your carrier question that. Give your carrier the facts, or if you're self-insured, that's your own direct money. And don't be fooled. If you have a carrier, it's more than your own direct money. You know, these carriers are assuming a certain level of risk, and in return, they keep changing your modification rating, the rates, because they have to eventually make up for the losses of all the COVID cases they've covered in the last 2 years. So you can question these things. You can provide information to the carriers. Most adjusters or administrators of that will look for your help to say, well, he said 5 people got it in your office, so he must have gotten it there. Well, the 5 people were all in the stock room. He works in accounting, so I'm not aware of them ever interacting because we no longer allow the stock room and the office to interact. So again, don't assume. Now, if those 2 people went out on a smoke break, illegally, in the sense that you don't allow that and they contracted it, that should be challenged as well. We had that with an employer. And, you know, the issue is, does workers' comp kick in immediately? No. Well, we're past the period where if there was an exposure, the employer had to pay for 2 weeks, or if someone had contracted it, they had to pay. That's long gone. So, you know, in one of the cases, when it goes back to, you know, people not being vaccinated, or refusing the vaccine, we put in place in our office, and I've done this, I've cut and pasted my policy for 2 clients, the fact of if you have your first of 2 shots, if you are not fully vaccinated, which we define as 2 weeks post the second shot or 2 weeks post Johnson & Johnson, and you contract the virus, we will pay you. We are not going to charge you your sick time. We're not going to charge you PTO. We appreciate the fact we're rewarding you for being vaccinated. Lamont always talks about this. And then the other side, as you sent in the same memo, is if you choose not to be vaccinated and you have an exposure, you go home and use your own PTO. And we're going to make sure you exhaust that PTO and not simply take, you know, unpaid time. And the same thing, if you're not vaccinated and you contract the virus, we are not paying you for that time off. You'll use your PTO. You know, let's, you know, think about rewarding in a meaningful way, not a gift card. You could do that as well if it works. You know, people that are, you know, in the process of being fully vaccinated and maybe contract the virus or have an exposure where they need to remain home. Going through some of these issues of work. You know, we're going to talk about occupational diseases. I'm not going to get bogged down in that because the governor had this issue of a rebuttable presumption, which is basically saying if it was really for healthcare employers, nursing homes, hospitals, that if you're treating people with COVID and an employee contracts COVID, we're going to assume it's at work. And sadly, you know, that goes against basically, you know, the scales of justice because it doesn't allow you to provide facts that they're going to believe in. Well, you could rebut the presumption, not in workers' comp that well. Workers' comp is a welfare system. Let's not forget that. Unemployment comp is a welfare system as determined by the Connecticut Supreme Court. So the scales of justice are like this, and you're the one trying to come back up. And so in that scenario, you know, get your act together in those situations, provide the information to your carrier, and so on. This is the rebuttable presumption. But basically what's happening now, I do a lot of these cases where there are crossover issues, meaning there's union issues where the union's picketing one of my clients because they're claiming this employee contracted the virus and now is in the hospital and is pregnant. The fact that her partner had the virus and her good friends had it was irrelevant. She must have contracted it from work. Well, we were dealing with the union issue more than the comp issue, and we were able to demonstrate this employee in a 3-week period before she tested positive had never interacted with any employee or patient who had the virus. But sadly, that doesn't get published in the newspaper. But, be careful. You have a right to present facts. And ironically, what's going to happen, and happened in that case, is the union immediately called OSHA about an unsafe workplace, lack of masks, and so on, which we know was a big issue early on. And OSHA came in and inspected, and we were able to get that dismissed, that OSHA complaint, with no financial penalty, because we demonstrated in this particular case that the employee always had masks, had access to masks, and did not interact with any COVID-positive patients. You're hearing a lot about, well, John, could I get them to sign a waiver? For example, I had the other day, John, one of my employees does not want to be vaccinated. I understand that if they contracted at work, it's workers' comp, and my rates are high enough. Could I make them sign a waiver of comp because they refuse to be vaccinated? And the answer is no. There's two, again, remember welfare benefit? Unemployment comp and workers' comp could never be waived, even in a full release or anything else like that. So the waivers are illegal. And what happens is, if you attempt to do anything like that, you almost get this label. And then others become aware of it, whether it be at the EEOC or the Commission on Human Rights in Connecticut, workers' comp or unemployment. So be very careful. Now, you could have other waivers for non-workers' comp benefits or unemployment comp benefits. And there's also this gray area of, that I'm dealing with now, of people being vaccinated and having side effects, most common with the second dose. And, one of my clients said, well, we didn't force them. We told them it's completely up to them whether they want to be vaccinated because we didn't think we could require it. I said, well, could I see the memo? And it was yes. And it had, the memo was very pro-vaccination, encouraging people to do it, praising people who were vaccinated, giving them a free lunch for a week. Well, as far as workers' comp goes, it's not voluntary, meaning that it's not covered under workers' comp like a bowling league or softball maybe, if it was encouraged. And so even if you don't require it, but you encourage it, which I don't know any employer who's not encouraging people being vaccinated, and the person has side effects from the vaccine, it's covered under comp. But, and I dealt with this, many of you may not remember this, but there was a smallpox vaccination program in 2002 that was voluntary by statute, and they found everyone who had side effects from the smallpox, which was a live virus vaccine, was covered under comp. But the issue is, are they disabled? And that's where, you could have a comp injury but not be disabled, so you don't collect any benefits. And some of the rules, and I know you have the outlines, is, in comp is the first 3 days are not covered. You have to use PTO and sick time. Some employers, again, we've done this in our office, we said if you do get vaccinated and you have fatigue or ill, we will give you 2 additional PTO days and possibly allow you to work up to 5. So in that situation, they're also less likely to file a comp claim if they know they're being compensated. But the real issue to watch out for, and I think it's brewing, is, and I know it's already out there for the COVID, is people that fear to be vaccinated because they have an unreasonable fear about vaccines in general, not religious, but more mental or psychiatric. And then people who've been vaccinated, including, I know one person, I was shocked, rushed to the ER because they thought they were dying or having a heart attack from the vaccine, which is not a live vaccine. And it was completely untrue. But I found out this friend of mine also has been rushed to the hospital a number of times believing she had a heart attack. So, that is the case where, wait a second, I got the vaccine, due to you making me get the vaccine. I had 1 or 2 days of physical side effects, but then I had this psychiatric overlay. And is that workers' comp? And the answer is yes. People don't realize that, but workers' comp claims that are recognized are physical that then become mental. And we've seen it, and it's covered under the ADA. If you've had these cases where people have gotten the COVID virus, are otherwise physically well based on their own doctor's examination of them after the 3 weeks, no long hauler effects, not even any of the common residual effects, maybe after a month. And they feel as if they still cannot work because they had the virus. Well, that's where you're in a delicate employment ADA area, where you really have to, speak to a lawyer and deal with those on a case-by-case basis. Because if they do get even an internist to say, well, emotionally she's not able to go to work, or she fears she still has symptoms, that's covered under the ADA, even if objectively they're not there. And we had 1 or 2, sadly they were manipulating the system, but we've had 1 or 2 employees for clients the past year who have used that and used the scenario of getting a note of not returning to the office before the vaccines, when the office reopened and they were needed, and they could not work remotely, the position, by getting a note from their doctor saying they were afraid of contracting the virus. Well, that may be covered under the ADA. That may be protected. So, I started the program early by pointing out, some of the items related to, that I'm surprised more people aren't coming in with psychiatric-based notes, because those would be the hardest ones to address, because it's not necessarily based on objective evidence of having a virus, not having a virus, suffering from the hearing loss, suffering from the taste, suffering from migraines. So I would just be involved very early on. If you're in HR or you sense something like that has happened or coming down the road, how do you address it? But please do not do this, which a lot of my clients do. Well, John, I just let them take off. Well, what are they doing? Well, I help them that, we have our own STD up to 6 months, which is, we pay for, and then it's the LTD, so I'm helping them with that. And I say to them, okay, well, do you think they could work? Well, yes. I said, do you have any unsafe conditions you're putting them in? He said, no, John. In fact, we were giving them to accommodate, remember that word? Accommodate them, we were moving them from a cubicle to an office. And also in an office where there'd be no people needing to come almost into her office. So she would be isolated, and actually she always wanted an office. We thought this might, prompt her to return, and the answer is no. So we're letting her stay out, and she's collecting these benefits. Then I sit there and say, which people forget, in HR I think you forget it the most sometimes, and I forget it, is, are the other employees okay with this? These other employees who've come into the office, who, had to maybe, someone that he was the, providing all the daycare during the pandemic. Now the kids have to go to daycare, and he's coming in because you're making him come in because you're requiring everyone to report. Is he okay with her staying home? Your HR, the perception sometimes is that, sadly, it's more in some of the union shops I work with, it's us against them. Well, you'll be shocked of how many times I've had employees in my own office, because I'm the HR manager, say to me, John, I was waiting for you to suspend her or discipline her. Everybody used to say, why does Michael or Jackie get better treatment than me? And I would say sometimes, and we all know this, and if you're in sales, you absolutely know this, sadly, people in collections and sales tend to be treated better than everyone else. But putting that aside, that's good in collections and good at sales. Putting that aside, you're not only enforcing these laws because you should be doing it, or enforcing someone to return to work who has no medical basis for staying out of work, but you're also doing it for the other employees who are in that office, who showed up at work, who got the vaccine, and maybe their arm still hurts and it's 3 weeks later. So, I tell people, is everyone else okay with this? And the answer is usually not. And remember, this reasonable accommodation, sometimes you're looking at it the wrong way. I've told some of my clients, okay, well, she's complaining or he's complaining that he has to go back into the cubicle. Give him his own office. Make sure you're monitoring him in that office. Remember our electronic monitoring policy. You're allowed to put cameras anywhere you want except the dressing rooms and the restrooms. And make sure that, they're doing work. And the biggest issue I've dealt with that people are still working remotely is some people are doing better remotely than when they're in the office, and some people are not. And the problem becomes, depending on the nature of the job, how are you tracking them? How can you demonstrate productivity? If you could demonstrate it objectively, well, John, they made 15 sales calls, 10 virtual, and actually 5 in person while they've been working home remotely, versus when they're in the office, they don't average 7. Well, I may change that position to a remote position. You have every right to do that. You could extend it beyond COVID if it's productive, and you don't have to do it for everyone in that class. So, don't think always about, well, everyone has to come back. Well, I judge it, well, do I have to have everyone come back because I'm going to have issues with other employees in that job or classification? Or am I just doing it arbitrarily when maybe there's some people that I would allow to work remotely because they're more productive? In my own office, when we have to do billing, I send the billing coordinator home because otherwise she's interrupted. I said, could you work at home for 2 days? Don't come in. And, that was well before the pandemic. So, when you have this new world we're facing, where remote work is something that used to be just an ancillary issue, think of it as to your advantage, and don't automatically. I had one client say, well, John, I'm bringing everyone back. And I said, okay, you're bringing these salespeople back. Have they not been productive? And actually, John, no, they've been more productive. I said, well, but I'm having the staff come back. I'm having managers come back. They need to come back. I said, well, are they being more productive because it was just that they did more sales because of the fluke of the pandemic? I said, no, our sales have nothing to do with the pandemic. We were expected to be hurt more by it, and we weren't because our salespeople were so productive. I said, well, could we reevaluate, this arbitrary rule that since you called everyone else back, you're calling back sales for them to possibly be less productive? So think out of the box. I don't, and please don't misunderstand this for a lack of caring and the horror of this virus, but there's opportunities here that you may see your business differently as a result of what you had to do during the pandemic. And we've done this for employers routinely. Draft a remote work policy. It should be very detailed. How about this crazy idea that remote work goes to people that work hard, that had excellent attendance, and their above average performance, versus tying it to a job classification? Why don't we reward certain people that want to do it and say, well, you have excellent attendance, you're above average performance, we'll try it out 2 days a week for this. Draft such a policy. It's like I tell people when they have personal leave policies. They say, and if anyone would like one, I can coordinate getting it to CBIA, and I'm happy to give it to you because I gave it out last year. Well, John, I was told the personal leave should be my sole discretion. Well, if I had a bulletin board, I'd write on it right now that said, sole discretion in my mind equals discrimination. Why not have personal leaves based on these crazy ideas of above average performance, excellent attendance, the reason for the leave? Let's throw seniority in there. Let's make our personal leave policy to reward our good employees. And your remote work policy could be the same way. You could discriminate in favor of excellent employees. Now, again, I'm not talking certain union situations. It may have to be negotiated. But, there's opportunities here as we're in this transition period to see what works for you and what has not worked for you, and maybe to reevaluate continuing that. And And so I know I'm getting off topic, but I'm just trying to deal with absences that were related to the vaccine, that are related to a fear of COVID, catching COVID, or the long haulers. But, you know, let me see what I have. The last thing, it's so funny, if you saw the front page of my program, you would have seen a date of, I think, May 4th, because the way the world is moving now, when I used to do outlines, it didn't matter. The ADA was not changing suddenly. The different programs I've done with the leave, the FMLA was not changing suddenly. We've known about paid family and medical leave for God knows 2 years. So I wrote this, to help people, because this is the most common letter I'm writing, about people being vaccinated, the need to be vaccinated, common areas. But I wrote this before the whole world got opened up in 3 days. So just quickly going through it, I tell all my clients, highlight that you're following OSHA, that you have an obligation, and then it's the promulgation of the various requirements of mask wearing and safe distancing. And this is encouraging. This is what I call the encouraging letter or the consequence letter. And we feel this can only be accomplished with everyone being fully vaccinated, which I define to be 2 weeks post that. If you are not fully vaccinated, you must continue to wear a mask at all times. We know that's true now, to maintain a safe distance. Or fully vaccinated, this is where the last part you have to change it. If you're fully vaccinated now, interacting with a non-vaccinated, you don't have to wear a mask, they do. When I wrote this just 3 weeks ago, you both had to wear masks. And then we try to define this, because we do know, especially with the Johnson & Johnson single shot, especially if you're a Yankee fan, you know this, with Torres, here's my Yankee, I don't know if you can see it, my Yankee mask. With Torres and 7 coaches, they all had the Johnson & Johnson vaccine. Torres actually had the virus, and 7 or 8 of these coaches contracted it again. And they were doing that because they thought it'd be easy to give them the Johnson & Johnson. But you still can contract the virus. And then I talked to you about the rewarding of people that we are going to give them 2 weeks paid time off if they are not yet fully vaccinated, or if they contracted and fully vaccinated. And in here, you'll see that we're not giving them the paid time off, and if they have exposures, they must go home. Now, the caveat I put in there is the whole world changes again, and you must stay for this paid FMLA, because I just think it's going to be the most abused leave in the history of Connecticut on January 1st, especially when the employees realize they're paying for that leave, at least this year. So, I know there are a number of questions. Diane is nice enough to help me read them because I'm old and I wear glasses.
All right, yeah, that was great, John. Thanks very much. I did want to ask you, this question doesn't necessarily have anything to do with COVID, but you mentioned it right at the start of your talk when you were talking about someone who had been out for 2 years. And this is a really common question that I get, and that is, at what point does the employer get to say, that's it, like you've been out long enough, I can't take it anymore, I've got to fill this position, so you're fired, without worrying about a retaliation claim?
That's an excellent question, and anybody wants to email me. I did that program, that topic, 2 years ago for CBIA in a similar program, and like I opened with, there's no workers' comp leave. So what are they doing? Well, they're automatically on an ADA leave, which we know now should be temporary in nature. It's sometimes a wraparound leave, or they're automatically on family and medical leave if they qualify for that. And please, I can't tell you how many employers say, well, John, she didn't get me the certification. John, they didn't give me the form. I said, help her. Maybe she's going to a doctor in the box and they're not going to fill that out. Because remember, whenever you're in a situation where you're going to eventually terminate someone for not returning to work, you don't want to be in a situation of terminated someone because their doctor, because they have a $6,000 a year deductible under your health insurance, wouldn't fill out the form. So automatically assume FMLA if they qualify, ADA. But where people get lost is they have this belief, and it's usually some workers' comp lawyer from the other side or some claims adjuster sometimes, a workers' comp adjuster saying, well, you have to keep their job for as long as they're recovering from workers' comp. Well, if you've ever had these cases, you know, there's some people, I have cases of people that are out 8 years with a bad back. They're still recovering according to their treater because the treater gets paid twice as much under workers' comp than under group health, 3 times as much than Medicare. So, you know, I tell people, and again, I'm happy to provide this because I gave it last year, is you all need a neutral absence control policy, which basically says that if anyone is out of work, I pick no less than 6 or 7 months because you got the 16 weeks Connecticut family leave right now, and then I give people a 6 to 8 week ADA wraparound accommodation leave. Remember, a leave is an accommodation under the ADA. And it basically says everyone is let go. Sadly, whether it be the person with cancer, a stroke, or the workers' comp person. Many of my clients pick 9 months. That way you have a neutral policy terminating everyone because most of the people out after 9 months are workers' comp. Now, you can make exceptions. You build it into the policy. You know, you don't want to punish the good worker who went for very conservative treatment, had a fusion botched, and 50% of people shouldn't even have these fusions, of their lower back, and now have to have a second fusion. So you could have exceptions. And we've had cases where clients said, well, John, I just have to terminate someone with cancer. I said, yes, and you could rehire them. I said, let me defend the case of preferential treatment for an employee who suffers from cancer. I said, there's nothing preventing you from rehiring them. So have a neutral absence control policy. And again, non-union. Union, you got to negotiate. And think about after 8 to 9 months terminating the employment on a case-by-case basis. There's no law preventing that unless you're terminating them because you're mad at them because they filed for workers' comp. That's illegal under the workers' comp discrimination law.
Okay, we've got another question that came in, and it has to do with an employee who comes in, a new employee who comes in and says he has a pre-existing condition. And the question is, what's the new employer's obligation for monitoring work conditions or keeping track of the workers' compensation claim? How does that work?
That's a very good question. Years ago, because of everyone discriminating against people because of their disabilities, Connecticut had this brilliant idea, but when they run things, it's always falling apart, that if you would encourage them to disclose a pre-existing back, and then if they had a new back injury, it didn't get charged to your workers' comp, which is, you know, tremendous cost items in certain industries. But what happened is that this fund that they created, which some of you may know is a second injury fund, actually went bankrupt. But you cannot discriminate against someone in a job application because they have a pre-existing condition. You have to be careful on your form how you're asking that question. And do you want that answer? Because, you know, I don't want to know if someone is disabled unless it's a heavy labor position, but then you make sure you give them the job description and you could do post-offer physicals. Because I don't ask those questions in an application because I don't want to know, because you'd be shocked, and you know what I'm talking about. People write down a significant number of mental and emotional disabilities, and I'm like, oh my gosh. So, you know, pre-existing, that's why you have workers' comp insurance. If they have a medical note of what they can and cannot do, that should be coming out in the application, the interview process when you give them the job description. So I would not focus on it. I would be careful if you become aware of it, that you're not putting this person in harm's way. I have that in my own office with a gymnast. And I keep saying, well, you know, I need you to get these boxes, but if you have a problem with your back, have Mary help you. But there's not much you can do there, but be careful about discriminating against them because of that pre-existing.
Okay, so what about the people who are working remotely? You've let them work remotely, but is there anything that an employer should do to protect itself or limit workers' compensation claims that could arise from the employee getting hurt actually at home, but while they're working?
That's a great question. Yeah. Basically, when you agree to let them work remotely, you moved the workplace to that house. Now, OSHA said we're not going in. Now, they may change that. They said that decades ago, that we're not inspecting anyone's home and you're not going to be liable if they have, if they have the dog's toy and they trip over it under OSHA, but you are going to be liable under workers' comp. Yeah, it's a Pandora's box of workers' comp claims because you can't deny it. Are you going to subpoena their 8-year-old child and say, is mommy or daddy lying? No. So yes, and the comp has allowed that. When you allow, it used to be salespeople working out of their house. Some famous claims are the person was shoveling the snow in the driveway, had a heart attack, and died. And they filed a comp claim, and the carrier said, well, this is crazy. They always shovel the driveway. How is this work related? Well, the spouse, the widow said, well, he was going to mail letters related to work. Well, there was no proof of this, and they won that comp case. So what's amazing to me is I think so many people appreciate working remotely because they're not forced to, that the workers' comp claims have gone down dramatically. So, I have not even had a phone call of anyone abusing it because they're afraid of being called back in to the office.
Interesting. So now, during the pandemic, are cases actually moving through the workers' comp process? Like the settlement conferences are taking place and cases are moving forward?
Well, we were talking about this with workers' comp and with the Commission on Human Rights. The nightmare is these remote hearings, these virtual hearings, in our opinion, and in the clients I talk to, are all benefiting the employee. They're not in front of you. They're not in front of a commissioner in human rights, a hearing officer where they're being questioned. They're sitting in their room. Some of them are with their lawyer who's literally touching, I've seen it in another video, touching their leg saying, don't answer that, don't answer that. And it's been horrific in terms of the Comp Commission because basically if the person just mentions they had COVID, which can be completely unrelated, or someone in their family got sick from it, the commissioners are bending over backwards, in my opinion. It's gotten better, but, it's a welfare system. And in this scenario, they're generally going to benefit the employees. So the commission, knock on wood, is supposed to go back to in-person hearings either June 1st or July 1st, which are clearly more beneficial to an employer. And Crow, we're requesting in-person mediations, even if we're the only one going. Again, to be in front of that hearing officer when we're presenting the post-answer mediation.
So, and then is that getting granted?
I'm sorry?
So then when you request that, are they granting those? The in-person?
Yeah, we're requiring depositions in person. We've been doing it for months. Safe distancing. We have sneeze guards. We have everything. And the commissioners have been allowing in-person depositions, which is very fair and great of the commissioners. They're not doing that in the court system. They're doing it in the comp system. But we are requiring, again, these formal hearings, which are the trials, and we want the doctor in person too. That if we have to cross-examine their expert who's getting paid $750 an hour to make up a story about sick building syndrome, we want him in that hearing. And we've been granted that, that right going forward,
right.
Now that the world is better.
Okay. So we've had a couple questions about FFCRA, and you were talking about giving paid sick leave to vaccinated employees, but not the unvaccinated employees. Were you talking about the FFCRA sick leave or just any? No,
that's expired. That if you're doing anything like that, it's voluntary. That obligation expired about giving that mandatory paid 2 weeks or paid time off with relation to that. We're not telling people to do it unpaid, but yeah, you have certain rights to treat people better who are helping you meet your OSHA obligation. Now, you can't discriminate against someone. Well, it just happened that everyone that they're not paying happens to be someone who is in a certain age category or religion. But yeah, you have no obligation to treat them the same on a going forward basis.
Okay, so just to clarify, there was a question that came in this may not be directly on point with what you were talking about, but just so we can answer the question, someone wanted to know if you can still get FFCRA paid leave for side effects from the vaccine through September 21. And I can just answer that yes. But like John said, this is a voluntary program. So if this is something as an employer that you're doing and you're giving this paid leave, and you're giving the FFCRA paid leave, that's your choice as an employer to do that. And so if you choose to do that, you can give that to your employees who have side effects through September 2021, and then you'll get the tax credit for that.
And that's the same thing. That's a good point. I'm sorry, I should have referenced that. And that's the same thing, you know, if you end up terminating someone that under that same bill, they have a right, you have an obligation to pay the 6 months of COBRA if it's an involuntary termination. That could be in the cases we're getting where the person won't return to the office, or the person's let go for good cause and you still have to let them know and pay for the first 6 months, and then you get a tax credit back. It's more complicated if you're a nonprofit in those scenarios, and that's something you need to talk to your financial people or your accountant about, because that tax credit doesn't apply unless it's related to the federal withholdings as it did previously.
Okay. So just on that issue, you mentioned you don't want to discriminate, right? So is that discrimination if you give paid leave to people who are vaccinated and you don't give paid leave to the people who are unvaccinated? Is that not discrimination?
Well, if you're required under the recent COVID pandemic bill, that's a requirement as it was previously requirement. It's not discrimination because it's not linked to anything. You know, if you linked it specifically to, well, anyone that's not getting vaccinated and catches the virus and the reason for not being vaccinated is psychiatric, then you're playing with fire, you know, assuming you don't have the obligation to pay them under the law anyway. So no, again, you know, what's your purpose here? Your purpose should be to have a safe workplace, and especially in the positions. And just, you know, one quick point, I had one client call me up and said, John, I just went to my board, and it says we're reversing this because I told the board I can't get anybody to work in the office. So if I have a rule that says you have to be vaccinated or you're laid off, we got a problem. So they literally, so be careful before you take these hard lines. Could you replace that clerk? I could replace a lawyer. I cannot get a $15 an hour clerk and replace that clerk. So, you know, what are they, cutting off your nose to spite your face? So something I should have touched upon is, you know, the practical reality because of this labor shortage, especially, you know, in scenarios of this additional 300 for lower paying people who are getting more on unemployment with the supplement than they are home. You know, you got to use your practical business sense and says, no, John, I can't enforce this. You know, in our office, I wanted to have it as a requirement, and my partners came to me and said, no, because you tell me where we can get X, where we can get Y, and I'll let you make it a requirement. And so the practical business side of it may prevent you from making it a requirement. And that's why I gave you a letter on encouraging. But again, the letter is old and has to be updated in light of, you know, what may be paid under the Relief Act and also what is the new laws as of 3 days ago.
Yeah, I think that's really indicative of a lot of the conversations we're having here at CBIA with our members. They, you know, initially one of the most common questions was, can I mandate it? And, you know, the follow-up is always, well, you can, absolutely, you can. Just be prepared for what that actually means. So if you mandate it, like you said, like you're the person you really need there, it doesn't get vaccinated, and so you're going to terminate them, right? So you just kind of need to think that through and make sure that you know, first of all, what you can do. Yes, you can mandate it. And then now what should you do? And that'll be different for each employer.
And just one quick add-on. I've been counseling certain people where they have this person who's have the history of just complaining, has a history of just doing the opposite of what the employer wants. And, you know, there's opportunities now to let people go that never existed. You know, we had this in my own office with a secretary who was just a nightmare. And it was right after we gave her a position, from a temp agency. And we just sat down with it and said, you're absent more than the whole office, you're late more than the whole office combined, 23 other people. It's not working out. We understand you have a child. If we let you, we'll work something out so you collect the 300. And now, if I did it now, I would go to that and say, and I'll pay your COBRA for 6 months. Well, once she heard she would make as much money home and not have to pay for health insurance, so more, or the employee share, she was very happy to work out that separation. So there's opportunities here where you may be able to work out separations, take advantage of the supplement and the COBRA obligation. So again, I always try to look at the glass half full and see where a certain law may benefit my clients or my own office.
Okay. Well, I think that's all we have time for today. John, thanks very much. And again, if any of you out there, if we didn't get to your questions or if you think of more questions, feel free to contact John directly. John, thanks again for your insight. And we're going to take a short break. So when we return at 9:20, we'll be joined by Heidi Lane from the Connecticut Department of Labor. So we'll see you then.
Our company has always had a long history of sustainability, and to that fact, we look to CBIA to enhance a number of the other programs that we've been working on, which would include solar, rail, make-up air systems, to heat our facility. We were also able to reduce our power cost consumption by hundreds of thousands of dollars. Our business is mainly centered around supplying a value-added raw material for both medical and food applications. I like to utilize them not just for the energy benefits, but especially during the pandemic, there was an awful lot of regulatory issues that we needed someone to use as a sounding board and to really just get through all the red tape and tell us exactly what we need to do so that our employees were safe and that we were in compliance.
Are you looking for additional training resources for your company? Let CBIA help through our partnership with Training Network Now. Training Network Now has thousands of safety and health videos on topics ranging from sexual harassment prevention to ergonomics in the workplace working remotely. For more information regarding pricing, please contact CBIA Membership Director Joe Diaz at 860-244-1118.
Are you aware of CBIA's extensive member savings offerings? Learn more about programs like our partnership with Training Network Now, an online service which offers safety and health training videos for your employees.
Just an incredibly difficult year for everybody. And from the beginning, I would call CBIA and say, listen, I've got this issue. Help me understand, clarify, translate for me. They are my go-to source. We're talking, plus 20 years for sure. ONG is close to celebrating their 100th anniversary in 2023. We have organizations and construction sites throughout the state of Connecticut. There's a strong focus on the education market, particularly our schools. At the end of the day, as an HR practitioner, you have a core set of trusted resources, and CBIA is one of them for me.
And we're back. Our next speaker is Attorney Heidi Lane, the Director of the Legal Division at the Connecticut Department of Labor. Attorney Lane has been with the Labor Department for 29 years. She provides legal counsel to the executive administration, directors, and staff at the department. She's also an invaluable resource to employment attorneys across the state. She's earned a reputation over the years as the source of information for Connecticut attorneys who specialize in employment law, but who nevertheless need help with the most difficult questions. Her areas of expertise include the Family and Medical Leave Act, paid sick leave, misclassification of independent contractors, break periods, electronic surveillance, and minors in the workplace. She's in high demand as a speaker, so we're very lucky to have her today to shed some light on the interplay between federal and state FMLA. Heidi, welcome, and thanks for being with us today.
Thanks, Diane. Appreciate it. You make me sound a little bit better than I actually am, but I'm okay with that. I am okay with that. So, should we just get started then? I hope everyone can see the PowerPoint. I just want to welcome everyone. It's been a long time since I've done one of these, so I'm very appreciative that people are there. I'm hoping you are. I have no way of knowing. And I'm sure that after my introduction that everyone stood up where they were and gave me a standing ovation. And I really, really appreciate that. That was lovely. So what I want to do is talk about federal, paid, and Connecticut FMLA, because there are differences. And although we tried to do what we could to make them the same, they are not all the same. So I want to start off with the paid leave. And just tell you that this is not within the department's jurisdiction at all. Anything having to do with the paid leave is within the jurisdiction of the Paid Leave Authority. I have their website at the end of the PowerPoint. They talk about a great resource. They are an incredible resource. They have a really good website, and it's very helpful for employers. And that's where you go register. I'm sure anyone who's listening has registered, I hope, and have begun to do the deductions from employees' pay. So they really are going to handle everything about the paid leave, almost everything. So they're going to, that's where someone will apply for the leave. That is, they're going to check the eligibility for benefits, and they're going to look at the medical certification, and they are going to communicate with both the employee and the employer. And they are also going to determine what they're going to do is they're going to look at the total earnings from Connecticut employers. So what they're going to do is they're going to look at the base period. Now, those of you who are knowledgeable about unemployment, the base period is the first 4 of the last 5 quarters. If the employee has earned $2,325 during that time, they are eligible as far as earnings. So that's how the Paid Leave Authority will handle whether someone is eligible as far as the money is concerned. So that's going to cover a lot of employees, and they are going to be eligible from day one if they have that $2,325. So then everything else will be looked at as well. So when we get to the next slide, I just want to discuss about Connecticut's role in the paid FMLA. We have a role. I'm not going to say it's small, but if anyone has been denied compensation from the trust fund or a private plan that the employer has been approved for, and they can appeal to us. So when I say us, I mean the Employment Security Board of Review. So those of you who know UI know that we have as our top level appeal within the Connecticut Department of Labor for unemployment is the Board of Review. Well, they're going to have a section of attorneys who will be handling these appeals. So it's going to be separate from the UI stuff. That was a good word to use, stuff. And then they're going to just be handling the hearings. Now we're trying to work out the hearing process. So we think we've got a way to do it. We think that we're going to be able to get the file from the authority when someone appeals. We think that when someone appeals, the authority is going to double check to make sure they made the right decision. Then it will come to us. So there are checks and balances here. I think they're going to do their best not to overwhelm the Board of Review with these appeals. Now, I'm going to refer to the Board of Review as the hearing officers, but when it comes to FMLA, everything that we have, and by we I mean the legal division of the Connecticut Department of Labor, remains the same. We have the same authority we always did. So nothing has changed there as far as the FMLA and our role, the Department of Labor's role in FMLA. Now, I want to discuss the length of the FMLA leave and paid leave. Oh, I need to just tell you that some of these slides, the charts and the ones that are really, really nice, were done by the Paid Leave Authority. I took it from them. I did get permission. So just want you to know the nice slides are them. So the nice little charts. So we have the protected leave, job protected leave, and then we have the paid leave benefits. This is something very important that you need to know, and that is paid FMLA is not job protected. So there may be a time when it is not running at the same time as Connecticut FMLA or federal FMLA. And in that case, it's not job protected. So for an example, so I told you that the criteria is for paid is $2,325 earnings in the base period. For the new Connecticut FMLA on 1/1/22, you have to have worked for the employer for 3 months. So when you work for the employer for 3 months, then you are eligible for Connecticut job protected law. So there is a possibility that if someone needs paid leave when they first show up on your doorstep on day one, they may need leave, but they are only eligible for the paid part of the FMLA. They are not eligible for Connecticut's FMLA. So that's why you're just going to have to track as much as you can what they are using and how they are using it and what's covered. And as we go through, there'll be other slides that show you how to, what you need to do when you get someone who tells you, I need FMLA or paid FMLA. So as we know, for federal, you get up to 12 weeks in a 12-month period. That is now the same for Connecticut's FMLA, beginning 1/1/22. All of the changes I'm talking about are effective 1/1/22. So paid leave is also 12 weeks in a 12-month period. So the employers who are used to the 16 weeks in a 2-year period, forget that. The employers who were used to the 16 weeks now they're going to have to see it similarly as they would see the federal. So a lot of times you will be able to run them together concurrently. I guess that's what together means. but not all the time. So, and then there's the military leave that CT FMLA has and federal FMLA has. And then there is the up to 12 days for family violence. Now, you probably know that we already have a family violence law. And for those who are really nerds, the site is 31-51SS, unless I just made that up and I'm really not sure. But I think that's what it is. So, but now, without the FMLA, if a person had to take leave because they had to move to another state due to family violence, yes, they would be covered and protected by the family violence law, but it would not be FMLA. And so, but now it will be. So that's an important thing to know. That is an added category. And something for the FMLA and the paid FMLA. Yes, the employer can still make us use our paid time off, but they can't make us exhaust all. We are permitted, employees are permitted to keep 2 weeks. So the other thing is there's also a possibility for 2 extra weeks for incapacity due to pregnancy. Now, for this, we've had a lot of discussion on this, and we believe at this point that it is only for incapacity that happens before the birth, because it's due to pregnancy, not due to birth, it's due to pregnancy. So we are going to be putting out guidance on all of these fine points, because it is difficult and it's confusing, but people just need to know how to read all of this. So we'll try and do we'll do more than try. We will do guidance, and we'll answer a whole lot of questions in the guidance, because we know this is confusing. Now, one thing is the new law on February 1/1/22, it will be for any employer with 1 or more employees. So that's one of the biggest differences between the old FMLA and the new FMLA. So I don't know if we have any of those people who have between 1 and 74 employees watching, but I am sure we're going to be doing some trainings along the way, and I'm sure CBIA is for those companies who really, they never had to worry about state FMLA before. Some of them who have 50 to 74 employees had to worry about the federal. But now everyone is going to have to worry about Connecticut's FMLA. Now the federal is not changing. Federal is still 12 weeks, and you still need to work 1,250 hours. So, and that's only for employers with 50 or more employees. That's the federal. So there's going to be a lot for the smaller companies to have to figure out and deal with, because they haven't had to deal with the FMLA before. So there will be some FMLA 101s coming in the future. So there are differences, as we can see on the next slide, between the current law and what's coming up, 1/1/22. So there is a new definition, and it's family members, and it's a spouse, sibling, son or daughter, grandparent, who is related to the employee by blood or affinity, and whose close association the employee shows to be the equivalent of a family member. Now, that's a lot to take in. What is that close relationship? How do we define it? Well, the Department of Labor is lucky enough that we were told we have to define it. We were hoping it was going to be in the law. But the legislature said, oh no, Department of Labor, you'll define it. So we are going to have to draft regulations that will explain what that means. Now, the reason we don't have all the answers here is because the regs are not completed yet. They will be. And there are things that we just don't know that we have to figure out. Now, that's why we talk to the folks at the Paid Leave Authority. I don't know if you folks have dealt with Andrea Barton-Reeves or Erin Choquette. They are phenomenal. And so we've been going back and forth with them on issues that plague us both, trying to figure out what something means. So we have to figure out what the close association means. And by doing that, we have to, what we've started doing is look at other states and other laws and see how they handle it. Now, for those of you who are always subject to the FMLA, federal or state, know that you are allowed to ask for something in writing from the employee to show, to explain what that relationship is, when we were dealing with the issue of whether someone stood in place of a parent when that child was growing up. So chances are it's going to be something similar to that, so you know the relationship. It can't just be a neighbor. It has to be someone who actually has a relationship with the employee who needs to take the leave. So the legislature also added the definitions on the next slide of grandchild and grandparent. So, we never had this before. What we did have was I really hate to do air quotes, in loco parentis. So if in place of the parent, so if I had a grandmother taking care of me when I was a child, day-to-day responsibilities, and I had to eventually take a leave for my grandparent, I could, because she stood in loco parentis to me. That's not in here anymore. You can just take a leave for a grandparent, whether they stood in place of your parent or not when you were growing up. So you can take it for a grandchild and grandparent, and that's big. That's a big expansion. The other big expansion is on the next slide, which is sibling. Siblings are now covered. Never were before, but they are now on 1/1/22. And the other thing with son or daughter, for those of you who have had the FMLA before, to deal with the FMLA before, you know that the definition of son or daughter was under 18. And then if you were over 18, there were other criteria that had to be met. That's gone. Now it's a son or daughter of any age. And that's important to note. So there are many changes in this law. So all of those definitions that I just went through, they are both in Connecticut FMLA and paid. So keep that in mind for when we go through slides later on. On the next slide, we talk about spouses who work for the same employer. Under federal and Connecticut's FMLA, you have to combine the two, the spouses. They get a combination of 12 job protected leaves for newborn and to care for a parent. So paid leave, there's no sharing. If an employer has spouses working for them, they both can take the 12-week. There's no change to that. So that's important for those who are used to the sharing concept. Paid leave is different. Now, the unemployment compensation benefits on the next slide. A lot of people we know are going to have to get a temp worker in for the 12 weeks. Because being without that person may be a struggle for the employer. So for this, if you have to get someone in as a temp, then when you eventually have to let that person go, you will not be charged unemployment insurance benefits. It will be pooled, so you are not responsible for that person who you have to let go due to a bona fide leave under FMLA. So at least that's something that you can hire someone and then let them go. Which brings up a very important issue, which is when someone is on a job protected leave, and I just want to talk about Connecticut FMLA right now, only Connecticut. They must come back to their exact same job, same shift, same responsibilities. Federal says you come back to your original job or an equivalent. So if you are running them together, a reason that's covered by both federal and state FMLA, follow Connecticut's, because you must bring them back to their job, not something similar, and not something different. Let's say I'm on a leave and you like the temp better than me. You're inclined to want to keep that person on and get rid of me, but you can't. Not under Connecticut's FMLA. You have to take me back. You're stuck. So that's a pretty important distinction between the federal and the state. I have to go back to my own job. Now, and that's even if you have separated my job among 3 current staff people. If my job is still being done, I get my job. You take those responsibilities away from the 3 individuals who are currently doing the job while I'm out. Now, the next slide is really important because it talks about what leaves are job protected and what are not. So the federal FMLA, of course, we know, is for employers in Connecticut with 50 or more employees within a 75-mile radius. We know that effective 1/1/22, any employer with one or more employees will be responsible for the job-protected Connecticut FMLA after an individual has worked for them for 3 months. Other job-protected leaves, workers' comp. I don't really know workers' comp, so I'm not really sure how that works, but it's job protected. The ADA is for employers with 15 or more employees. But just to jump down, Connecticut Fair Employment Practices Act covers any employer with 3 or more employees. ADA is for 15 or more employees. But in Connecticut, the ADA is pretty much subsumed within Connecticut Fair Employment Practice Act. So ignore the 15 plus employees and just sort of follow the requirements under the Fair Employment Practices Act in Connecticut, because that includes most of the disability issues covered by the ADA. So if someone takes a leave and they cannot, and it's after 1/1/22, and they cannot return to work, their healthcare provider says, could you please take 2 more weeks off and then you'll be fully recovered. Now, courts have gone different ways on that. Some courts say that the additional 2 weeks could be FMLA. And some say, no, it can't be FMLA. And some say it falls under ADA as a reasonable accommodation. So when it comes to anything over the 12 weeks, you might want to just think about that issue, because a leave may be a reasonable accommodation. And the paid sick leave is also important to keep in mind. And that's for employers with 50 or more employees in Connecticut. And that is the up to 40 hours in a 1-year period. And don't ask me why, but there are only 69 categories of people who are covered by the paid sick leave. I don't know why it was done that way, but no one asked my opinion, so I wasn't able to give it. So it's only 69 categories. We have a page on our website dedicated to the paid sick leave. So, and we have guidance there if anyone needs additional guidance on the paid sick leave. So now, what laws give us income replacement? And it is the paid leave, which we're talking about now. It's workers' comp, and it's the paid sick leave. So those are basically the laws that you need to look at. Now, on the next slide, it talks about what you have to do when someone requests a leave. So what you have to do is look at all the job-protected leaves and the non-job protected leaves. So if we look at the previous slide again, when someone talks about, okay, I go up to my employer, I need a leave. And the employer has 100 employees. So what laws could possibly affect that? Well, the federal has, the federal might, CT FMLA might, workers' comp, pregnancy, fair employment practice, and paid sick. So you have to look to see which ones apply. Now, I know this is hard, but you have to look through each one to see if anything applies, and then you have to apply that. And the same with the job protected side. You have to know, the non-job protected side, just the income replacement. So for an employer with 100 or more, if I come to you and I say, I need leave to care for my grandmother, and my grandmother did not take care of me when I was a child, I just need to take care of her because she's elderly and has a serious health condition. So you have 100 or more. So let's look at the federal FMLA. It's not going to be covered under the federal because a grandparent is not a family member under the federal FMLA. So the federal hasn't changed. So you are only running Connecticut FMLA. That's it. So remember, that person still has a bucket of federal that they have available. So that's what makes this very confusing. And I didn't say that. It's perfectly straight. Everyone understands this, which is why we really need to do our job with guidance. So if I need to take a leave for a child who is 30 who broke her leg, again, not federal, because they don't cover a child over 18 unless there is a physical or mental disability as defined by the ADA. Now, I know I'm going over a lot of issues, and for people who have never had to worry about the FMLA before, I know this just must be very confusing, but I'll just talk about a few basics in a minute. So I am taking a leave for my 30-year-old daughter with a broken leg. So we know that's Connecticut FMLA. It's also paid FMLA because I've worked for the employer longer than 3 months, and I've earned $2,325 in my base period. And there actually is a serious health condition as defined by the FMLA. A son or daughter who's 30 is covered by the FMLA. So those will run at the same time. So you have to look at each individual circumstance to see which law is covered. So it's a little difficult because you have so many laws to track. But once someone is eligible for the FMLA and the paid FMLA, that should be at least easier. Now, the circumstance where I've earned $2,325, but I haven't yet worked for the employer for 3 months, that's where it gets a little tricky, because and I need a leave on day one. So the first 12 weeks are not job protected, but I still get my whole entitlement once Connecticut FMLA kicks in. So there are some cases where people will be doing leaves back to back. There will also be some cases where people will be doing state FMLA and federal FMLA back to back for the employers who have 50 or more employees. So I take a leave for a daughter who's 30. We know that's not federal, so we can't count federal. So I still have my federal available to me for a reason covered under the federal FMLA. So that's why you actually have to take your time and look through the laws and decide what you need to do, which ones are covered. Now, with the pregnancy leave, the pregnancy leave is, we know it's a serious health condition under the state law and federal and paid, but that may be a time when someone gets to use 12 weeks of leave before the birth because they need bed rest. But then, so it looks like she's out of all FMLA, but the Pregnancy Act in Connecticut guarantees someone at least 6 to 8 weeks for the recovery after the birth. So 8 weeks for cesarean. So in that case, the person could get 12 plus 6 after the birth. No one, every woman generally after birth gets at least the 6 weeks. So even if they've run out of FMLA, they generally get the 6 weeks. So let's go to the next slide where we look at, again, the decision matrix. So this is what you have to do. Someone comes to you and says, I need leave to care for a parent who's in a nursing home. Okay, what laws apply? The laws that apply are, depending on the size, federal FMLA, Connecticut FMLA, and paid FMLA. So those will apply. And there may be others, and you just go through them. So you have to look at those issues each time. You have to look at job protection and income replacement. So those are, it's the best way to make sure you are covered. I mean, there are some where you know off the bat it's not workers' comp, so you don't worry about that. If someone comes and tells you it's for a parent, you know it's not workers' comp. On the next slide, we do talk about workers' comp, and this is one slide that they gave me a lot of slides, but this slide is from the paid FMLA because an individual who's receiving workers' comp benefits is not eligible for paid leave. I actually didn't know that, so I'm glad they had a slide on that. And on the next slide, it talks about how an employee can receive paid leave benefits with the employer paid benefits at the same time, as long as it never exceeds 100% of their wages. So those are some of the criteria and some of the rules that you need to follow. Now, the paid FMLA people have already started doing lots and lots of training. I know they've done them for CBIA a number of times. So, but what I want to talk to you about is someone coming to you and saying they need a leave. So the first thing is you have to decide, okay, which laws are applicable. And as a reminder, if someone just comes to you and says, I'm sick, or calls in and says, I'm sick, I need some time, please, I need some time off. We know from past cases that that's not sufficient. There is no way you know whether that's an FMLA leave or not. Just saying sick is not sufficient, so you don't have to start the entire process. But if someone comes to you and says, I need to care for my mother, then that's when you have to go through the regular process that you go through. You tell them whether they have to use their accrued leave or not. And remember that, let's say I have 10 weeks of accrued leave. You can't make me use 2 of them for this. I get to keep 2 in reserve for something else. Now, there will be instructions by the paid FMLA people as to how to handle the requests. The employer is sort of out of the process. It's the employee that has to be paid, and it's the employee who applies and gives their med cert. Now, I'm not sure what type of med cert they're going to use. I'm not sure they've decided. I don't know if they're going to use the same one we use. We use the federal. But if they develop their own med cert, and if we look at it and it looks like it fits our purposes as well, then we'll use theirs. But we will keep you posted on that. There are a lot of things that we don't know yet. We hope to answer them under when we do our regs. When we do our regs, and this is a really boring process, but I need to tell you, we draft our regs, we post our regs, and everyone has 30 days for public comment. So you can write in and say what you don't like about the regs. There won't be anything you don't like. And so don't bother. And then there's a further process where we need approval from other entities. But we hope we have to have our regs published for public comment within the next few months so we can meet the 1/1/22 deadline, because they have to be effective by then. So look on our website. We'll keep you updated. And look on the next slide. I have the website for the Paid Leave Authority. It is a good website. And so remember to use it. And then at the very last slide is contact for FMLA issues for Connecticut. So remember, anything having to do with pay, leave us alone. Go to the Paid Authority. Diane, there is time for questions. Are there any?
Oh, yeah, we got questions. But it sounds like the most important thing is leave you alone if it has anything to do with pay, right? Just don't.
Leave us alone.
Okay. So I saw you put your contact information on that slide, and that was going to be one of my questions. I mean, surely you don't really want all these people calling you. So you know how there's that neat ask us a question at the bottom of the Paid Leave Authority website. Is there something at the Labor Department, or is there some resource that people can go to, not for the paid leave stuff, but the regular Connecticut FMLA stuff?
You know, that's a really good point. And I think we will do that because we've talked about that. I think I'll just make a little note on that. Mailbox, because now it's when we just had the employers with 75 or more, you know, that was what, 3,200 employees? I'm sorry, 3,200 employers, and I can't remember how many hundreds of thousands of employees that was. But now that we have, I don't know, 140,000, 150,000 employers and over 1 million employees, Diane, I think that's a really good idea to do that mailbox. But we do welcome emails. I mean, that is our job. We don't just do FMLA, so please remember, if you don't get an answer within 2 hours, please don't write again. But yeah, that's a great idea.
Okay, thank you. Thank you for giving me that credit. So I just want to clarify, a couple questions have come in. I think people are surprised about some of the changes to the Connecticut FMLA, not the paid version. So just to clarify, there's no such thing anymore as 16 weeks. Is that right?
Correct.
Okay, but that starts January 1st, 22?
Yes.
Okay. So,
yes, it does.
All right. So in 2021, if someone takes 12 weeks of leave, like people can still get 16 weeks worth of leave in 2021, just not in 2022 or later.
Correct.
Okay. So that was one question. And then the other one was, now there's no such thing, nobody cares about that 75 employees thing. That's no longer a thing.
Right, it's one or more. That's it.
That's crazy. So in Connecticut, think about FMLA in Connecticut if you have 75 employees. Now it's think about it if you have 1 employee. Is that right?
That's right.
Okay.
Did I mention I didn't write the
law?
Yeah,
you're not in charge. Yeah, no, I heard that. Yeah, I heard that. Okay. All right. So I wanted to just follow up on that example you gave. I know people are like starting to sweat. Like this is like worst case scenario. So you mentioned that example with the, let's say you're taking care of a child who's 30 who broke their leg.
Mm-hmm.
Okay, so that's not, let's say you have 100 employees, like you said, right? So you're covered by everything, all laws, you're covered. But that person would not be entitled to federal FMLA leave, right? That's what you're saying. So then does that mean that there might be a situation where someone would get their 12 weeks of FMLA under Connecticut law, because that's going to be covered with a 30-year-old's broken leg, and then later on in the year, they could get another 12 weeks covered by the federal law, or would they be capped out at 12?
No, because the Connecticut FMLA for the daughter who's 30 is not a reason under the federal law. So they can't run together.
Right, so people are going to be getting potentially lots and lots of weeks of leave, potentially. Some under state, some under federal.
It's possible.
Okay.
Which is why you have to go through that matrix, because you need to see. So, Diane, anytime that there is a difference between the federal and the state eligibility criteria, federal's not going to run at all. So let's say in my 4th month of employment with my employer, there is, I need a leave. So I've made my $2,325. I passed my 3-month mark. I am eligible for paid FMLA, Connecticut FMLA, not federal because I have not earned my 1,250 hours. So that's another instance where they have to be separate, and you still have your bucket of 12 weeks under the federal.
Okay. All right, so one question that came up, this is, I shouldn't be cynical, but I doubt you're going to know the answer to this, but it's something to maybe to look into. People are wondering, do you know of any methods of tracking all of this? Have you heard of anything, any resources that people are coming up with that will help HR managers track all these different leaves other than just like going through their timesheets?
I don't know of any. I know there were some out before, but I don't know if now they're out with Connecticut's new FMLA. I'm actually thinking, I wonder if some third-party administrators may have that type of thing. I'm really not sure.
Okay.
I'm really not sure, but yes, you're right. I did not know. I do not know the answer.
Okay, so that'll be, maybe that's just something that HR, all the payroll people and the HR people out there, you can kind of network with each other, see if you can see if anybody has some form that they're finding might be useful. It does seem like this is, I mean, without a doubt, this is going to be confusing, right, to track all these different laws. So we'll just have to do our best in that respect. So another hypothetical, if let's say you have a person who goes to the paid leave authority because they think they have an injury or an illness that qualifies for paid leave, and that's rejected, then does the employer get notice of that rejection, and then the employer might still have to provide unpaid FMLA because it might actually meet the definition of the unpaid version?
The employer, yes, I do believe that there is notice to the employer. I think they're working that into their system.
Okay.
The employer should look at the med-cert and make their own determination whether it's FMLA. I mean, I'm hoping that most of the time we're going to agree with the paid leave authority. But the employer is going to have to look when they find out that someone is applying for paid FMLA, they're going to have to look at the med-cert as well to see if it falls under Connecticut's FMLA. So they're going to have to do both. There'll be the paid part, and then they'll have to look to see if it's FMLA.
Okay, so if you're the employer, you don't wait to see if the paid leave is granted or denied, and then if it's denied, then you start your regular unpaid. Like you look at it as soon as it happens, and you start providing it as soon as you believe the employee is eligible.
I certainly would, because remember, the FMLA has timeframes.
Right.
It's, what is it? 2 to 5 days. No, I think ours says 2 days. You have to let them know what they have to do, whether they need the med-cert or not, whether they're eligible. Employers have to give that information pretty quickly. So I would not wait for anything. Right now, our law says 2 days. We're hoping to see if we can change it to a longer period of time, even just to match the federal 5 days, because 2 days is a little too short. So we're seeing if we can do that.
Okay. So, and you mentioned earlier in your talk about how really the only involvement that the Labor Department's going to have with the paid FMLA is with appeals, right? And that would be the Board of Review. So,
yes, exactly right.
and you were saying that maybe you haven't finalized all those procedures yet, but do you know if a case is on appeal and it goes to the Board of Review, do you think that the Board of Review will want the employer to participate, to come in, provide a statement, or is it kind of looked at as, well, that's a PFMLA thing, so the employer will just go to the authority?
You're exactly right. The employer is not part of that appeal. The appeal will be between the authority and the employee, and then we'll make the determination as to whether it was properly denied. So the employer is out of the picture on that because it doesn't really matter to the employer. Well, yes, it does, but they're not a party to the appeal when they appeal a denial of paid FMLA.
Okay. What about, do you know, there's a question about PTO, and this has to do with paid leave, paid FMLA. Do you know when...
What, Diane? No paid FMLA questions. No.
I know. I actually knew you were going to say that, but I'm thinking maybe you might know the answer to this. So do you know, well, you mentioned the eligibility number, the 2,000, what was it, 350 makes you eligible?
Something like that.
So do you know, does PTA go into that factor? And does PTO get considered when determining benefits, or is it just based on hours actually worked?
It's based on hours. What the what the authority is going to look at is the employer's wage records that they send in to us. So I think an employee will also probably have to send in a pay stub, but for unemployment purposes, every employer has to file quarterly. So if they look at our records, they will be able to see whether someone has met the $2,325 threshold in the base period. Okay. So that'll be simple enough. And remember, employers don't have to do any of that. They don't have to figure out how much the employee is getting, whether they're eligible. The authority is going to do all of that.
Okay. All right. Well, Heidi, thank you very much. Thanks for answering all the difficult questions. You got kind of a beating, I think, at least from me. So I'll be laughing if you get hundreds of those phone calls because you put your phone number on that slide. I
left the phone number on, or did I just email?
I don't know. I thought I saw your phone number. Maybe it was just your email.
Well, if I did the phone number, yeah, emails is so much better.
Okay. All right. Well, again, thank you very much. We're out of time. We hit all the questions, and so we'll see you next time.
Thanks. Thanks, Ann. Bye-bye.
Okay, so now we're going to take our second break. We'll return at 10:30 when we'll discuss the Americans with Disabilities Act and how that law interacts with FMLA issues. We'll see you then.
I consider them my partner. You know, that's really that's how I feel about CBIA. My name is Cynthia Ambrose, and I'm the Human Resources Manager for Integrated Physicians Management Services. We're located here in East Hartford on the river. The bulk of what we do on a day-to-day basis is medical billing. We also are experts with compliance. So we've been working with CBIA since the beginning of my tenure with this company, which is 31 years. I call CBIA generally for employment law related questions or benefits. I find that I pick up the phone quite a bit.
During these unprecedented times, CBIA is finding new ways to enhance your benefits package without affecting your bottom line. CBIA's home and auto insurance program is an additional benefit of your membership, requiring no additional dues dollars. There's also no administrative work and no payroll deduction, making it fast and easy to provide open enrollment options for new employees and new hire packages. CBIA offers discounted rates that aren't available to just any agent. We work with some of the top insurance carriers in the industry, all rated A or better by AM Best. While tailoring coverage to an employee's needs, our licensed professionals will check coverages that they have currently and close any gaps that exist. We also offer more than just home and auto insurance. We can provide coverage for all personal lines, including renter's insurance, condo coverage, and specialty coverage for RVs, boats, and any other valuables. To get started, contact Ruth Galinsky at CBIA.
Are you looking for additional training resources for your company? Let CBIA help through our partnership with Training Network Now. Training Network Now has thousands of safety and health videos on topics ranging from sexual harassment prevention to ergonomics in the workplace working remotely. For more information regarding pricing, please contact CBIA Membership Director Joe Diaz at 860-244-1118.
Our company has always had a long history of sustainability, and to that fact, we look to CBIA to enhance a number of the other programs that we've been working on, which would include solar, rail, make-up air systems, to heat our facility. We were also able to reduce our power cost consumption by hundreds of thousands of dollars. Our business is mainly centered around supplying a value-added raw material for both medical and food applications. I like to utilize them not just for the energy benefits, but especially during the pandemic, there was an awful lot of regulatory issues that we needed someone to use as a sounding board and to really just get through all the red tape and tell us exactly what we need to do so that our employees were safe and that we were in compliance.
Welcome back. So now, as I warned you at the start of the webinar, we're going to really get into the weeds of the ADA, the FMLA, PFMLA, EFMLA, and the PDA, with a focus on the employer's duty to provide reasonable accommodations in the form of leave. So with me here now, virtually, that is, are two attorneys from the law firm of Murtha Kalina. Patricia Riley chairs the firm's Labor and Employment Practice Group and co-chairs the firm's Education Practice Group. She litigates employment and restrictive covenant cases in state and federal courts. And she also appears before the CHRO, the EEOC, the Connecticut Department of Labor, and the U.S. Department of Labor. In addition to maintaining a thriving litigation practice, Attorney Riley advises clients on a wide range of employment law matters, including sexual harassment and discrimination avoidance, disability and pregnancy accommodation, FMLA, wage and hour compliance, and trade secrets and restrictive covenants. Last year, Best Lawyers in America recognized her as Lawyer of the Year for New Haven in both employment law and labor and employment litigation. Sal Gangemi is a partner in the firm's litigation department and is a member of the Labor and Employment Practice Group. Mr. Gangemi advises clients with respect to state, federal, and local employment laws, handling matters in federal and state courts and before administrative agencies, again, like the EEOC, CHRO, the New York State Division of Human Rights, the New York City Commission on Human Rights, and state and federal labor departments. He counsels clients on day-to-day issues involving workplace management and administration, including requests for reasonable accommodation for disabilities, for family and medical leave, and wage and hour issues. He also conducts employment law training on a variety of topics like sexual harassment prevention and wage and hour compliance. So Tricia and Sal, good morning, and thanks for being here.
Good morning, Diana. Thank you for having us. Good morning, everyone, and welcome. So we call this alphabet soup. Why? Because we have so many acronyms, it's hard to keep them straight, as if you aren't all confused enough having listened to how paid family leave is going to change the landscape. We're going to layer on additional leaves of absence for your consideration and how those all interact with one another. I will say that our emphasis is less on paid family leave because Heidi covered that, but we're going to mention it a little bit, and things will change when that goes into effect on January 1st, 2022. But what Sal and I have observed over the past 14 months is definitely a change in what is considered a reasonable accommodation under the law. And our view is that now that we have understood people can work remotely in certain jobs, the employer is going to have a higher burden of proof to show that telecommuting, for example, is not a reasonable accommodation in certain kinds of jobs, particularly office-based jobs. And we're going to talk you through some of this so that you can understand. Now, what leave laws are we talking about here today? We're talking about the Americans with Disabilities Act and the state equivalent under the Connecticut Fair Employment Practices Act. We're talking about currently, as we all know, the Connecticut Family Medical Leave Act. Unpaid is 16 weeks, and it applies to employers who have 75 or more employees. All of you on this call today who have a workforce of one or more employees, of course, you're here because you're paying attention to the Connecticut Paid Family Leave Act. And so as of January 1st, 2020, the threshold is no longer going to be 75 employees. It's going to be one employee. And that 16 weeks is going to be brought down to 12, as I'm sure you heard Heidi mention, and there will be other changes. The Federal Family Medical Leave Act of 12 weeks will continue to remain in effect. So that will not change with regard to how you implement that. It applies to employers with 50 or more employees. So if you are an employer with 49 employees, you're going to have to worry next year, as of January 1st, 2022, about Connecticut paid family leave and Connecticut medical leave, but not about federal. Okay, and so as I say here, as of January 1st, 2021, all employers with one or more employee will have to consider the Paid Family Medical Leave Act. We also layered into this discussion Pregnancy Discrimination Act, because that is a required leave law in Connecticut, if it applies, that many employers forget about. And the Paid Family Medical Leave Act that goes into effect on January 1st, 2022 is actually going to add 2 additional weeks for pregnancy related conditions. So while we all think of the PFMLA as being 12 weeks, it's 12 weeks plus 2 for pregnancy discrimination, for pregnancy related conditions. But currently you must administer leave of absence for a pregnant employee if that is required by her physician. It can be deemed a reasonable accommodation, and it's currently unpaid. But as of January 1st, you will get, the employee will get potentially 2 weeks of paid under the Paid Family Medical Leave Act for a qualifying pregnancy-related disability. And the other thing that's not on the slide is the Connecticut Leave Act for domestic violence. That entitles someone to up to 12 days of leave for to deal with situation relating to domestic violence. That is also going to be covered under the Paid Family Medical Leave Act. So in other words, if you qualify for domestic violence leave, you would be able to get that paid under the Paid Family Medical Leave Act. Currently, you are allowed to get that unpaid under Connecticut law. So while that's not specifically listed here, the Domestic Violence Leave Act is also part of this alphabet soup of leave laws that we have to consider in Connecticut when an employee has an issue that may require a leave. Okay, next slide, please. So as I mentioned earlier, the pandemic broadened our idea of why people may need leaves of absences. Now, we do know that there was a specific leave act that was passed precisely and limited to COVID-related illnesses. So I want to make the distinction between these traditional leave laws that continued to be available during the pandemic. So that's what's currently in place in Connecticut, including the current FMLA, that make the distinction that next year, as of January 1st, 2022, there's going to be paid family leave available. And then on top of that, currently, of course, we have the pandemic leave. Now, that was extended by the American Rescue Plan Act for employers to use voluntarily until September 30th. So the current emergency paid sick leave and emergency paid family medical leave will expire on September 30th, but it is available currently voluntarily for employers who wish to consider it and get the tax credit benefit under this law. Now, this law applies only to employers with fewer than 500 employees. So if you have 501 employees, you cannot obtain the tax credit and provide this under the law. You can provide it, but you're not going to get a tax credit for it. And what does it entitle the employee to? Emergency paid sick leave. Again, this is COVID related, so of up to 80 hours. My view on this, again, is that particularly in Connecticut, with such a high vaccination compliance rate and a very low rate of COVID-related illness right now, and schools reopening, I mean, it's the end of the school year, but getting toward the end of the school year, I think that these leaves are going to be less relevant, particularly in Connecticut. But this is really a slide that's a reminder that they are available if someone still needs them for COVID-related reasons. Again, the emergency paid sick leave of up to 80 hours and the emergency paid family medical leave, which is 10 weeks, including pay to care for a child whose school or place of care is closed or the child care provider was unavailable because of COVID-19. This was very much needed during the height of the pandemic. It is being used less and less frequently. I rarely see this being used currently. So, but, perhaps still, particularly with some daycares are still closed, some schools are still doing some hybrid model. But the focus today is more on the traditional leave. And then as of January 1, 2022, the paid family leave.
Tricia, I'd like to interject if you don't mind. Your voice sounds so wonderful, and I hate to come in and sort of break up the.
No, please do, Sal.
So one of the things that the American Rescue Plan did with respect to the pandemic leave laws is they created a new qualifying reason for FFCRA paid leave. Initially, it was basically related simply to your own COVID-19 related condition, or being unable, schools were closed and being unable to have a caregiver care for your child due to COVID-19. But one of the newest qualifying reasons, which is something you may see again for a short time, is absences, vaccine-related absences. Okay, so if your employee wants to take time off to receive a vaccine, you can certainly allow them to do so under the FF. First of all, we recommend that everyone permits their employees time off to go do that. But under the FFCRA, you'll also get the benefit of a tax credit if you're allowing them time off for that.
That's a great point, Sal, and we talk about vaccines a little bit later, but I think it's an excellent point to raise now that is the one area in which this law is still very relevant and should be used if the employer wishes to take the benefit of the tax credit. Good point. Okay, next slide, please. So we cannot see the slides on our screen. I don't know. Can you see the slides, Sal?
Yeah, I can see it up. I can see it.
All right. Well, I'm going to go ahead. I can't see the slides on my screen, so that's going to be somewhat of a disadvantage for me. But let me try one thing here.
Well, all right. Do you see it now?
Yeah. Mm-hmm.
Okay.
All right, so disability and medical issues during the pandemic. During the pandemic, as we were saying, the idea of what an employer can do expanded dramatically in terms of inquiries into health. All of these kinds of inquiries were very much forbidden by the EEOC prior to the pandemic. But during the pandemic, public health took precedence. Okay, so an employer could take someone's temperature before they came in, could request that they certify that they didn't have any COVID-related symptoms. The employer could request doctor certification for return to work, which you can request, obviously, as we know, under certain circumstances. But really, it was on the front end of taking temperatures, of administering COVID tests in the workplace. That was almost unprecedented. When's the last time you could ever think of an employer being able to administer a medical test on the work site? So that was a huge sea change. But what I think we really need to be careful about now is that we're transitioning back to pre-pandemic considerations as businesses open. And we have to think about how has the landscape changed currently and how will it continue to evolve. The fact that you could take somebody's temperature during COVID and perhaps still for some period of time may be able to do so, and that you can ask somebody if they're vaccinated or not vaccinated with regard to COVID, if you want to go down that route, or that you can mandate COVID vaccines if you want to go down that route. All of that is going to be changing. Just because you could mandate COVID vaccines doesn't mean you could necessarily mandate other vaccines unless you're in a specific industry such as healthcare that might require that kind of thing. So we now have to think about, okay, the employer's ability to inquire of medical issues for an employee really expanded. And now we have to think about how long is that going to last, and how does that implicate, other kinds of things in the workplace. All right, next slide, please. So what is the new normal going to look like? I mean, it's coincidental that today is May 19th, the day that Governor Lamont is saying we're reopening. So of course, we're going to study his guidance and see specifically what he is saying is required or is not required. But in Connecticut so far, it's an honor system. It is, that's what he has been saying, and we'll see if the official guidance is correlates with that. And store owners and retailers are saying, we don't want to be, the vaccine police. So I've heard a range of options here. I've heard some employers, businesses, for example, forget about retail, but regular businesses, some are saying, okay, we're a business, no more masks required. And we're also not inquiring, no more masks for fully vaccinated people. And we are not going to inquire whether you're fully vaccinated. We're doing it on an honor system. So some businesses are going that route. Some businesses are saying, we have a high interaction with the public. We still want to protect our employees. So front desk workers, for example, who are greeting the public, we're going to ask the public who comes onto our premises to continue to wear masks. And we're giving, the front desk worker the option. I mean, if they're fully vaccinated, they feel comfortable, they don't have to wear a mask, or if they wish to, they can do so. So there's going to be a lot of, hybrid situations. So we're going, and then the question also is going to become, what about reasonable accommodations under this new normal? So has the pandemic changed the landscape for what constitutes a reasonable accommodation in the workplace? And my view is yes, because once you let the genie out of the bottle that many people are working at home remotely, it's very hard to justify, oh no, this backroom billing person absolutely has to come into the office. That's not to say that they get what they want, and that just because someone asks and has a doctor's note supporting the request for an accommodation, that they automatically get it. You still have to enter into the interactive process. And if there's some compelling reason why you as a business need that billing person back on site, you just need to make the case for the compelling reason. But it's, there's going to be a lot more focus in the courts and at the Commission on Human Rights and Opportunities on the process. I think it's going to be impossible for you to get a request for telecommuting and to deny it outright without there being some kind of process involved when that request is supported by a doctor's note. Next slide, please. Okay, so when I drafted these slides, what did I know? I always say I'm the worst person at predicting the future. I'm the worst. I always get it wrong. So literally, I think we did these slides maybe like 10 days ago, 7 days ago. Okay.
More like 48 hours ago.
48 hours ago. Like, okay.
Right.
Bullet point wrong. So, I guess you could say they're going to be in play to some limited degree to the, extent that I just mentioned it, that maybe some places will still want masks. Obviously, some areas, healthcare, schools. I mean, there are going to be some places where masks are still going to be required, but for many businesses, fully vaccinated people in Connecticut do not need to wear a mask, and CDC guidance is consistent with that. So again, accommodations will still be requested, but employers can examine the requests in light of the existing circumstances. So, if you really do have a team of billers and they have to be in the office because it's just more efficient and I could show you something really quickly, and this person worked at home remotely and their connection was never good, and they buzzed out and we can never reach them, those might be some of the reasons why that person has to come back into the office. Now you have to balance that against what the doctor's note says and why the doctor is saying they need a reasonable accommodation. And don't forget, as an employer, you can also suggest a different accommodation. That's the whole point of the interactive process, is it's a discussion, and just make sure that you document the discussion. That's what courts look at. And are you being reasonable? So if a job was performed remotely, does that now have to be consideration? Yeah, it has to be consideration, but it doesn't mean it has to be granted. Okay, next slide, please. Okay, so COVID-19 vaccines, as Sal correctly pointed out, under the FFCRA, if you are applying for the tax credit and you want to pay employees for taking time off for getting the vaccine and, recovery period from the vaccine, then you could take the tax credit. But even if you don't go through the official tax credit system and you just want to provide this as a benefit to your employees, many employers are increasing a PTO bank to say, look, we're going to give everybody across the board 4 more hours of PTO. We hope you use it to go get your vaccine. But I've had employers just give it to everybody so that they, again, are not policing who's getting it, who's not getting it. So the EEOC does allow employers to mandate vaccines, but is it a good idea is the big question. And it really depends on the nature of your workplace. So we have long-term care clients who mandate vaccines. That is very, very acceptable and almost necessary for their workplace, right? Healthcare providers have mandated vaccines. Some factory clients have mandated vaccines where people are working very closely together, et cetera. So if you have a justification in your workplace for mandating vaccines, it may be a good idea. We could support that. But conversely, many offices and businesses don't need the employer to be policing employees, because there still has to be the consideration for a reasonable accommodation. So next slide, please. Okay. So this voluntary compliance is really what I was saying is what is the best option for your workplace, voluntary compliance or mandating, in terms of voluntary compliance, providing incentives. You could do it that you only provide the additional PTO to the employees who bring in their vaccine cards, and then you will know who's vaccinated, who is not. I've had employees say, well, can we treat vaccinated and non-vaccinated employees differently? Well, I mean, technically you can. You can say, and you could do it on a voluntary basis if you're vaccinated, fully vaccinated, no need to wear a mask pursuant to CDC guidance and Connecticut guidance. But if you're not vaccinated, we would ask that you still wear a mask. Now, how are you going to enforce it? Are you going to require employees to provide you with the vaccination card, or are you going to do it on an honor system? In which case, anything that differentiates employees masked versus non-masked is inherently susceptible to creating conflict in the workplace. So my view on this distinction about making some people masked, some people unmasked, et cetera, it's going to cause conflict. And that's, just something that you're going to have to deal with in terms of then how do we want to resolve that conflict? How do we want to address the conflict before it occurs? Do we want to do it on an honor system? And then we have some other employee coming and saying the person next to me is not wearing a mask, and I know for sure they're not vaccinated. Then you have to intervene in the employer as the employer and say, you're not vaccinated, so you have to wear your mask. I could just see this creating some stress in the workplace, but that's what you get paid to deal with, I guess. So that's what we're here for, to help you try to resolve it. Okay. All right. So next slide, please. All right. Accommodations for vaccines. So this is what I was just about to mention, that even if you mandate that employers get vaccinated, if you as an employer decide that your employees have to be vaccinated, you still must, under the law, accommodate anyone who has a medical reason for not being vaccinated. So, for example, they have some kind of allergy to something in the vaccine, or this is a bigger pitfall for some employers, a religious accommodation. So someone can have a sincerely held belief that having the vaccine is against their worldview, their religious worldview. So it doesn't have to be necessarily an established religion, but it has to be a worldview that's based on something other than just their personal opinion or a political opinion. But that's a whole other area that, it's interesting. We don't have case law on that yet, but I have a feeling that the political opposition to the vaccine is going to find its way into some of these cases in the upcoming years. But, the fact of the matter is that's why mandating vaccines, if you do it, you still have to accommodate for these two reasons, medical and religious. So then you have to ask yourself, do we want to go that route, or do we want to do the incentive route? Again, there are specific reasons for you as an employer to make either decision, which is reasonable and can be supported by the law. Okay, that's it for me. Over to you for slide 10.
Okay, sure. Okay, so let's talk a little bit about the background on reasonable accommodations. So we've seen this concept of reasonable accommodations touch on a lot of statutes, even beyond disability discrimination or religious discrimination. But for now, let's talk about a disability accommodation. An individual is protected under the law if they're what we refer to as a qualified individual with a disability, which essentially means that they can perform the essential functions of their job with or without a reasonable accommodation. Okay, in assessing whether something's in a reasonable accommodation, the law essentially requires us to engage in what's referred to as an interactive process. The law wants to see an exchange, a dialogue between employer and employee that will hopefully, and in a perfect world, results in an accommodation that everyone can live with. Next slide, please. So an employer is permitted and is required to explore other options, not just the one that an employee requests as far as a reasonable accommodation is concerned. If an employer gets to choose, if there are two accommodations that are reasonable and both would allow the employee to perform the essential functions of the job, then the employer is permitted to take the less costly or less disruptive option. You're not required to accept the accommodation that the employee wants. You're only required to accept an accommodation that's reasonable, that's effective, that gets the job done, and that doesn't impose an undue hardship. Now, this concept of undue hardship is tough because it's a very, very high standard for employees, for employers to satisfy. It's not just a matter of whether it results in high costs to the employer, although that's certainly a consideration. But it looks at to what extent does the requested accommodation disrupt operations and disrupt the organization. These are things that you are permitted to take into account, and you should take these into account. And in fact, I recommend. In fact, there are some states that have laws that require you to document this whole reasonable accommodation process so that you can, if required to, later on, hopefully you won't, but if you're required to justify why you made a determination, a specific determination, one way or the other regarding somebody's accommodation, you're able to refer to this documentation that shows that you made reasonable inquiries, that you engaged in the interactive process, and that you really made a good faith attempt to try to arrive at a suitable or a reasonable accommodation. So in the next slide, we ask the question, what is an essential function of the job? Okay, because an essential function of the job is something that you're not required to write out of a person's job responsibilities. So well-written job descriptions usually identify what those essential functions are. And I'm not saying that those job descriptions will say an essential function of this position is X or Y or Z, although that's not a bad idea to state it in those terms. But it's important to differentiate in a job description somehow between essential functions and marginal functions, okay? Because you could be required to disregard a marginal function of a job in connection with a reasonable accommodation request. So has the pandemic changed the essential function of a job requiring an employee to be present in the office? As Trish said, it depends. And while I do think that it becomes more difficult to claim that remote working is, that working on location or on site is an essential function of the job because of what happened during the pandemic. People were working from home. One of the things that I saw during the pandemic is that because of the circumstances, employers had no choice but to allow people to work remotely. And as a result, they might have taken out some of the essential functions of that person's job. All right, because those essential functions couldn't be performed. And in a lot of cases, it really didn't matter that those essential functions couldn't be performed because the nature of the business changed anyway. And an example of that is like an event person, an event planner, right? There were very few in-person events, okay, during the pandemic or in 2020, and there are a few now as well. So in those instances, an event planner, and I'm just giving that as an example, an event planner could be accommodated working remotely during the pandemic because some of those essential functions weren't really critical, but that doesn't mean now that carries over into the situation we're in now, where now we can go back to basically doing what we did before. And in those instances, it may not be possible, okay, to permit an employee to work remotely. But again, this is a case-by-case analysis. You're never going to hear a lawyer, or you're never going to hear us, I should say, come out and tell you a remote working is always a reasonable accommodation, or that it's never a reasonable accommodation. You should never hear that, and that's in fact the case. So in the next slide, we've got some considerations too that you have to take into account. For example, pregnancy-related conditions and pregnancy itself, okay, needs to be accommodated in some states. Okay. For example, in Connecticut, since 2017, you've had to accommodate the pregnancy itself. Pregnancy-related conditions you've had to accommodate for a long time, and those are medical conditions or disabilities that are closely related to pregnancy. But now pregnancy in and of itself has to be accommodated. And it looks like, and I think Tricia blogged about this yesterday, or maybe today, I think it's going to be released.
It got posted today.
It got posted today. The federal government now has decided to get on the bandwagon, although many states like Connecticut, like New York, and like Massachusetts have already required these accommodations for pregnancy. Now, age is a tricky one, and we need to be very careful when it comes to age. Okay. I remember early on in the pandemic, governors of different states were advising people in their 1 hour conferences that they had almost daily. If you're over 65, don't go to work or work from home. Okay. That basically was that signal caused a lot of employers to say, you know what, I feel bad for so-and-so. They're over 65. I'm going to tell them they can't come in. Well, you can't do that, right? There's this concept of, under the law, that even your best of intentions can burn you, right? You can't be paternalistic.
You know what I say there? You know, Sal, my saying for employers, no good deed goes unpunished.
Oh, that's exactly right. That's exactly right. You know, I remember a few years ago, because I do a lot of work in New York, and I was shocked by some of the guidance that New York City had put out. For example, a woman, years ago, I defended an employer who didn't want a particular employee working near, in a medical office, working near radiation or involved in any of those procedures. And so they basically moved her out, okay? But she didn't want to move out, okay? She moved out. Now, at that time, courts were saying, well, look, you know, this was a reasonable thing to do. You can't do that anymore, okay? You can't do that anymore.
Right. Your point is very well taken. Accommodation does not mean that the employer takes it upon itself to be paternalistic towards somebody because they are either of a certain age category or pregnant. You're pregnant, so therefore, we don't want you to lift heavy boxes anymore. Well, if they don't have a doctor's note, if they haven't asked for that accommodation, you don't take it upon yourself. Right. But if they've asked for it, in Connecticut, then you have to consider the accommodation of, weight restrictions for lifting, for example. That's a great point that I think most employers know that, but it bears reiterating.
Right. So be careful with age. Now, so let's go, but we'll go to the next slide. But, having said that, in terms of talking about age, the Age Discrimination Act and even Connecticut law doesn't really require you to accommodate an older worker due to age. All right. It's really just a disability. It's really a disability, an accommodation that you have to be concerned about. Now, it just so happens that older employees may have a disability or age is correlated with having a disability, but that's not the same thing as in requiring or imposing an obligation to reasonably accommodate an employee simply because they're older.
Right. And if you do anything based on age, you're going to get an age discrimination claim.
That's right.
So we want to be really clear, while it is the case that during COVID, governors were saying 65 plus, stay home.
Right.
We both had calls saying, okay, so does that mean we should tell our employees 65 plus stay home? And we said, no, you cannot mandate that based on age. Now, if you get somebody who happens to be over 65, they have asthma, they're obese, they have, diabetes, and they get a doctor's note that says they cannot come to the office, you're accommodating the disabilities, not age.
That's right. Okay, in the next slide, let's get back to the pregnancy accommodation issue. You can't exclude an employee from the workplace due to these pandemic-related concerns that you might have. Again, it's a paternalistic attitude that the law prohibits. But again, if the employer requires it, it has to be done. Connecticut law requires an accommodation of a pregnancy-related condition, which would also include a reasonable leave of absence. But now we're going to talk about that more on the next slide, where we talk about pregnancy discrimination. So it used to be pre-2017. Then when we looked at pregnancy, we really the focus was on pregnancy-related conditions that were similar to disabilities and that should be treated as other disabilities. Since 2017, and now under the federal law that's likely to be enacted, it's basically discrimination on the basis of the pregnancy itself, okay, and childbirth and related conditions. And when we're talking about childbirth and related conditions, we're also talking about requirements for breastfeeding. Okay, accommodations relating to breastfeeding and to express breast milk at the workplace. And there are laws that essentially cover all of those things. And, 15 years ago, these laws didn't exist. So it's nice to see that we're making some progress in the world. But in addition to pregnancy, what kinds of pregnancy-related conditions are we talking about? Well, something as simple as nausea. Figures a guy would say something as simple.
Good one.
Nothing that I have absolutely no, that's no big deal, right? Morning sickness, no big deal, right? I would know. Dehydration, low blood sugar, anemia, hypertension, preeclampsia. Preeclampsia has always been one of the, whenever you saw cases that dealt with pregnancy-related conditions, that was usually what we dealt with, or that was usually the pregnancy-related condition at issue. Postpartum depression, that's a big one. Okay, that's something that needs to be considered. That's something that needs to be considered under the ADA, regardless of whether it's a pregnancy-related condition, because the ADA, deals with not only physical complications or physical impairments, but also deals with mental or emotional impairments. And employers are required. Employees are required to employers are required to inform employees of their rights under these laws. So let's talk about some reasonable accommodations, which we have in the next slide, in connection with pregnancy. So for example, more frequent breaks, longer breaks, sitting or eating while working, assistance with manual labor, okay, job restructuring, time off to attend appointments and temporary transfers. It also includes a reasonable amount of leave time following childbirth, somewhere in the neighborhood of 6 to 8 weeks. Now, the law does it, the pregnancy discrimination laws or pregnancy employment laws don't necessarily mandate a specific period of time, but 6 to 8 weeks is seen as, what is most typical under the circumstances.
And can I say here, we've had cases because what happens is if somebody gets, let's say they do have a very difficult pregnancy and they're on bed rest, in month 3. I just litigated a case like this. They were on bed rest since starting at the 3rd month of their pregnancy. So they were able to take FMLA to cover some of it, but then the FMLA ran out before they even gave birth. And the question becomes, does the employer then have to continue with an unpaid leave of absence for the balance of the pregnancy and then the delivery? And it's really an unsettled area of law in Connecticut because of this really generous accommodation and leave requirement. And so if you are going to deny an employee, pregnant employee, that amount of leave, you have to have a really strong reason to do so. And if you can accommodate the leave and fill in the job, with other people doing it, that's the safer course of action, because this is the cutting edge of pregnancy discrimination law in Connecticut. So now it's going to be interesting as of January 1st, 2022, if you have 50 or more employees and you're covered under federal FMLA, and you have the Paid Family Medical Leave Act, and you have Connecticut Family Medical Leave Act, when you start stacking all of these leaves, it's going to extend the amount of unpaid leave and paid leave that somebody's going to be entitled to. And then the amount that you as the employer may have to say, well, we're just giving them additional unpaid leave for this, is going to be less. So that's going to be interesting to watch how these things play out. Starting in January, the amount of leave available to people is going to be much greater.
So it's all yours, Trish.
Okay. So my unreasonable accommodations here, you've gone over that. So a new accommodation standard. So this is kind of a reiteration of what we were talking about earlier. Has the pandemic set a new standard for accommodation? Still and always under the law, disability accommodation requests must be considered and assessed on a case-by-case basis. As Sal was saying, you can't have a yes all the time or a no all the time, or we're definitely going to do this or we're never going to do this. The courts look at the process. They look at the documentation for the process. They look at the back and forth with the employees. There have been cases where because there's sufficient documentation showing the employee asked for something, the employer says, we can't do that, but we can do this instead. The employer says, I don't want to do that instead. I want what I want, and end of story. The employer says, I'm sorry you feel that way, but we're offering you this. This will work. This is in accordance with what your doctor's requiring as well. And those cases, the employer has prevailed. But the reason the employer prevailed in that case that I'm thinking of right now is the employer offered a reasonable accommodation that was going to work. But if you don't, if it's a hard no on first ask by employee, that is not the way the process is supposed to work. It often goes back and forth. It often goes, getting the doctor more involved, getting more information from the physician. It's a long process, and that is the point. That's what the law wants.
I'm sorry, Tricia. I wanted to go back. I neglected to mention something before, but it's something that I dealt with a few times during the pandemic with this concept of reasonable accommodation. Providing a reasonable accommodation doesn't only apply to performing the job itself, but it applies throughout the entire process, including the application process. So we had a situation where an applicant needed a reasonable accommodation in order to interview or apply for the position. The employer's concern was that this person might not really be able to perform the job. Our advice in that situation, and I think it's the right advice, is, worry about that later. First, concentrate on accommodating the applicant's request in terms of interviewing. Okay, accommodate that, and then if it looks like this person is a viable candidate based on all the other circumstances, then consider whether or not you'll have to provide a reasonable accommodation, or whether you can provide a reasonable accommodation that can allow them to perform the job. So
that's a great point. Some applicants will ask for the reasonable accommodation right up front, and you cannot just say, no, you're not getting the job because you're asking for a reasonable accommodation. That's going to cause a lawsuit. Or if they need a reasonable accommodation for an interview process, there are a lot of lawsuits having to do with website accessibility. So all of those things need to be considered by employers, definitely. So again, this is the same thing that we've been emphasizing earlier, which is that pre-pandemic case law, there were cases that say, being in the office is an essential function of the job. You have to be here. And they did not examine further whether it was an essential function of the job. That has changed. And now office type jobs, whether it has to be done in the office or not, it is going to be incumbent upon the employer to prove why it really needs to be done in the office. And you can do that if the person was not performing well, for various reasons remotely, and you need them in the office, that's fine. Now, there are certain other jobs that are clearly frontline workers, factory jobs, healthcare jobs, retail jobs. You can't do those remotely. Okay. But as we were saying, back office staff, such as billing, again, you cannot just out of hand say, no, you have to be in the office. You have to have a discussion with the person. You might consider the length of time. If they say, look, I only need 2 more weeks, that's such a short period of time. You might say, okay, and then back. Also, sometimes it happens 2 more weeks. Okay, then we want you to come back. And then they say, oh, no, I need 2 more weeks. But you need to consider it again on a case-by-case basis. Can we do it for another 2 more weeks, et cetera? Like I said, it's a process. It can be a long process. And what the courts look at is the documentation on the process and the reasonableness of the employer. The more reasonable you look, the better it is for you. All right. Next slide with regard to accommodation for family members. Okay. So the FFCRA does allow employees to take time off for family members, but the ADA, the Americans with Disabilities Act, does not require accommodation for family members. Let's remember that. That's under the ADA. FMLA, paid FMLA, can be taken for care of family members. And as Heidi said, Connecticut Paid Family Medical Leave Act, and starting January 2022, Connecticut's FMLA is going to have a very expansive version of what is considered an employee. It's very, I'm rather a family member. The definition of family member under the Paid Family Medical Leave Act and the Family Medical Leave Act as of January 1st, 2022 is going to be greater than under the FMLA. So the law is more expansive in that regard. And it's a long definition, so I'm not going to read the definition here, but you can look it up. Or
it's so convoluted and long that Patricia and I found out that we're related somewhere down the line. Aside from the fact that we look alike, aside from that, we
have the same sense of humor. So
or lack of a sense of humor, right? A lack of it.
That's very funny. So it's called, just to get into it a little bit, it's under the PFMLA, and the FMLA in January. It's related by affinity. Any person with whom the employee has a significant personal bond that is like a family relationship, regardless of biological or legal relationship. It may include foster child, friend of the family in whose home the employee lived while she was in high school. It's a good thing for families because it really does expand the definition on our uncle, child. It provides the true caregivers with the opportunity to take care of their family member. So I really think it's a very progressive. It's long and elongate, and long, but you have to really read this and understand it as an employer because it's expansive and it includes so many more people than you might define as family member. But it's helpful to the employee who, if that employee's primary role is caregiving for an extended family member. Okay.
Right. If you look at the laws the way they were, they excluded in-laws in some instances.
Right. That's right. So this has a more realistic view of what a family is. Okay. So again, let's go to the next slide regarding disability accommodations. Want to just keep in mind, of course, we know that disability includes mental illness. Okay. So mental illness should be treated the same as any other disability under the ADA and CFIPA, and can include job restructuring, but not eliminating an essential function of the job, temporary transfers, modifying work schedules, which may be one that we find works sometimes for mental illness issues, telecommuting, as we've talked, ad infinitum about, and other possible accommodations. Again, I like to say, let's start with the doctor's note on this ADA or CFIPA request. So, what does the doctor's note say about what kind of accommodation do they need? And then if you need more information from the doctor, you may need to get an authorization release from the employee to speak directly with the doctor. Unlike under the Family Medical Leave Act, with the ADA and the CFIPA for accommodations, you can have a discussion with the doctor if that's going to be helpful, or you can ask the doctor for more information and give them a form and indicate what the essential functions of the job are and what accommodations are being requested or modifications, that sort of thing. Okay. Okay, so next slide. As we've said, leaves of we talked about telecommuting as a potential accommodation, and I say, and the EEOC has said that just because telecommuting was an accommodation during the pandemic, it doesn't have to be an accommodation post-pandemic. So, so you have that EEOC support, but again, that's what they say. As a practical matter, you must explore it because you can't just shut somebody down when they have a request. All right. And next slide, as we've been saying, you know, the whole point here is the overlap. The alphabet soup here is that a leave of absence can be an accommodation, and it can be a reasonable accommodation. So when you're looking at a potential leave of absence as an accommodation, you're also looking at the FMLA, soon to be the PFMLA, also the federal FMLA that does not change. And the PFMLA, this is a big issue for employers, in my view. The PFMLA, paid family medical leave, does not require the employer to hold the job open. So for most of these leaves of absence considerations, the issue becomes, we can't hold this job open. And even the case law under the ADA says you do not need to hold a job open indefinitely. So if you don't have a return to work date, they say we need, 3 years, that's unreasonable. But some courts have held certainly 6 months to 1 year leave of absence is reasonable. So you have to be careful there. But the PFMLA, if someone is not qualified for FMLA, which is going to be 3 months in Connecticut as of January 1st. So you have somebody who starts working in the second week and then they get sick and they take their PFMLA. The PFMLA does not require you to hold the job open for them. Does the ADA require you to hold the job open for them if they've only worked there for 2 weeks? I think that's still it depends consideration. Now, given that we're going to have the PFMLA in Connecticut and it doesn't require an employer to hold the job open, I suspect that the way the cases are going to go is somebody's on PFMLA, we're not required to hold the job open. But I still think you should consider it. I mean, if they're only going to go on PFMLA for 2 weeks and then they can come back and do the job, should you hold it open? Sal, I'm interested in your thoughts on that because the PFMLA, if you take it up to, before the 3 months entitles you to FMLA, as to which you do have to hold the job open. What about this early, I've been a 1 month employee, I have a heart attack, I have to take time off under the PFMLA. Is my employer required to at least consider whether they have to hold my job open under the ADA?
I think that's right. I mean, specifically under the ADA, there's no time requirement for employment or anything like that. So I would absolutely say that it's something that should be considered, regardless of the tenure, the employee's tenure.
So employers are going to have to be careful there. CFIPA, which has an accommodation requirement for disability, applies to employers with 3 or more employees. And the ADA, the federal law, applies to employers with 15 or more employees. But the CFIPA, the lower standard of 3 or more employees, it basically uses the interactive process model. So that's where I think employers could get really, that's kind of like that little gray area where PFMLA says, if your employee's only been there for a month, takes PFMLA, under PFMLA, you don't have to hold the job open. But is there another law that requires you to consider giving them that leave of absence and holding their job open? I mean, I think that's where play.
And that's the problem when you're dealing with laws that specifically say you need to provide X, and they're very specific. And then you have these other laws, the loosey-goosey ones, which don't really give you much guidance other than to use like legalese and lawyerly terms like reasonable, a reasonable amount of time. Yeah, it's tough. It's very tough, particularly for smaller employers. Right.
And the smaller employers, like, as you're saying, have the potential to say, well, this is such a high burden, we can't afford it. And so that is a defense under the ADA and under CBIA that the cost is prohibitive. Don't forget also your sick leave, your short-term disability policies, Connecticut paid sick leave, long and short-term disability policies. We didn't go into Connecticut paid sick leave much in this conversation, but that's another thing that gets layered on here to consider. Are they entitled to any Connecticut paid sick leave? Okay.
What's the next?
Sal, you're on number.
Oh, I'm on. Okay, so in order to give us some an opportunity to answer some questions, I'm going to go through these a little quickly, simply because I'm hoping that we're not going to be talking about this a year from now. About asking employees whether they're experiencing any symptoms. Hopefully, to the extent that this is still happening, and it should be still happening, regarding employees who are coming to work. You really should have a policy in place and a protocol in place for addressing these issues. And you can require employees to self-report. And in the next slide, we talk about what the current CDC requirements are regarding quarantine, at least 10 days after symptoms. And you can, at this point, request a doctor's note before returning to work. Employers can administer COVID tests. I've never been a fan of having an employer administer a COVID test unless this was a healthcare employer. I just think there were too many risks involved for a non-healthcare employer to have those types of tests performed on premises. In the next slide, we just have a quick reminder here regarding confidentiality of medical information. In the next slide. So, it's not changing over, but anyway, okay, there we go. Always make sure that employees' medical information, that would include workers' compensation type forms, all right? Because we do have outbreaks of COVID in the workplace that are required to not only be reported to OSHA, but also can form the basis of a workers' compensation claim. That information should not ever be placed in a general personnel file or that employee's individual personnel file, because not everybody who has access to that personnel file is entitled to see that employee's medical information. Okay, so that's something to keep in mind. Again, in the next slide, we talk about a high risk, or what we might consider a high risk employee not requesting an accommodation. Again, the Americans with Disabilities Act and Connecticut law does not mandate that an employer take action. However, if the disability poses a direct threat to that employee's health or safety, okay, and it can't be limited by reasonable accommodation, then we have greater leeway in taking action. So, but this direct threat defense, or this direct threat piece, it's a very, very, very high standard. You'd have to show as an employer that allowing the employee to come in, this high-risk employee to come in, poses a significant risk of substantial harm to his own health. And the mere fact that we're talking, let's say, about a disease or a condition that the CDC has listed on its list, like COVID-19, that's not enough, okay, to justify finding that there is a direct health risk, direct threat risk involved. So in the next slide, we go over some best practices that Tricia and I have already covered. Okay, but if you want to see them, and if you don't believe us, there they are. Okay, and looking to the future. Okay, so things are going to change in the next few months, and I think things are going to change. I'm hoping things are going to change quickly, because hopefully more and more people will be vaccinated, and the spread of the virus will continue to decrease. And hopefully a year from now, we'll be able to do this in person, and we won't be saying a word about COVID-19. All right, and that's it. Next slide, please. If anyone has any questions.
Okay. I can't even imagine that situation, Sal, where we're actually not saying anything about COVID. So guys,
Normal.
So there was actually so much to talk about. We actually don't have enough time for questions. So if you guys out there, if you've submitted questions, I'm sorry we couldn't get to those, but you can contact Sal and Tricia directly. You can contact me at CBIA, and so we will do our best to answer those. Sal and Tricia, thank you so much for your expertise. We really appreciate it, and we will see you next time.
Thank you.
Bye-bye now.
So we're going to take our last break of the day. We're going to return at 11:40, and at that point we'll talk to Steve Latanzio from the Connecticut Department of Labor, and we'll be talking about the state's shared work program. So we'll see you soon.
Our company has always had a long history of sustainability, and to that fact, we look to CBIA to enhance a number of the other programs that we've been working on, which would include solar, rail, make-up air systems, to heat our facility. We were also able to reduce our power cost consumption by hundreds of thousands of dollars. Our business is mainly centered around supplying a value-added raw material for both medical and food applications. I like to utilize them not just for the energy benefits, but especially during the pandemic, there was an awful lot of regulatory issues that we needed someone to use as a sounding board and to really just get through all the red tape and tell us exactly what we need to do so that our employees were safe and that we were in compliance.
Are you looking for additional training resources for your company? Let CBIA help through our partnership with Training Network Now. Training Network Now has thousands of safety and health videos on topics ranging from sexual harassment prevention to ergonomics in the workplace working remotely. For more information regarding pricing, please contact CBIA Membership Director Joe Diaz at 860-244-1118.
Are you aware of CBIA's extensive member savings offerings? Learn more about programs like our partnership with Training Network Now, an online service which offers safety and health training videos for your employees.
Just an incredibly difficult year for everybody. And from the beginning, I would call CBIA and say, listen, I've got this issue. Help me understand, clarify, translate for me. They are my go-to source. We're talking, plus 20 years for sure. O&G is close to celebrating their 100th anniversary in 2023. We have organizations and construction sites throughout the state of Connecticut. There's a strong focus on the education market, particularly our schools. At the end of the day, as an HR practitioner, you have a core set of trusted resources, and CBIA is one of them for me.
Welcome back. So our last segment of the day will address a slightly different kind of leave, one based not on an employee's injury, illness, or disability, but on an employee's leave from work due to lack of work at the company. Steve Latanzio is joining us from the Connecticut Department of Labor, where he's a principal attorney with the Office of Program Policy. He's worked at the Labor Department for over 33 years and is the principal legal advisor to the director of the Wage and Workplace Standards Division. He's going to give us some much needed information about the state's shared work program. Steve, welcome. Thanks very much for being here.
Thanks, Diane. But my pleasure to be here. And hello, everyone. I recognize that I'm in the last time slot of the morning, and I intend to be respectful of everybody's time. I know how probably anxious people are to have this be concluded, and I will try to accommodate within 20 to 30 minutes, something like that. I never thought of the program I'm going to speak about, shared work, as part of the maze of leave programs, like leave of absences that are very difficult, in the work environment. But upon reflection and upon being included in this, I can see it now. I can see how shared work is viewed as a type of partial leave, a leave of a few hours, or a leave of a day of the week. And like all leaves, the important part of this is that the employee stays attached to the employer, and the employer to the employee. I've entitled this this talk today as like the shared work program as a hidden gem of the Labor Department, working with labor and with the government. There aren't, to be frank, many gems to be talking about, to different speaking engagements. However, this one is, and it's kind of universally viewed that way by both the employment and the and the employee community. I'll start with the basics of this. Much of this you may know already, but there are some nuances that just might be helpful to know. We call it shared work in Connecticut. At the federal level and other states, they call it short time compensation. It's abbreviated as STC at the federal level, but they're all synonymous, one and the same. The purpose of this program is as an alternative to layoffs. We have had the program since 1993, but it has really come into its own during the past couple of years due to this pandemic. It's normally viewed as an alternative to layoffs in a temporary decline in business. Temporary used to mean something no greater than 6 months. However, with this pandemic and this current climate, everything has been extended and lengthened. And now the shared work program is renewable for up to a 2-year period. We've adapted to meet the needs of the pandemic, which has, as everyone knows and as everyone has experienced, has had just dramatic effects on everything in all forms of business and government. As I mentioned, this is one of the most popular programs for both employers and employees. Most employers experience with the unemployment compensation system may not be viewed in the most favorable of context. This one, however, I think will be different for what we talk about, and it is popular. It genuinely is. I don't think I'm, over exaggerating that it's popular for both employers and employees, because there is advantages to both sides, and we will go through those. At the outset and throughout this, and upon the conclusion of this, I just want to refer you to this particular website, which is it's the bottom of this screen, which is www.sharedworkct.com. This will contain just about every piece of information and every form you would ever need or desire, and give you contact information for you to reach people to talk about any nuance of this. Continuing with the basics and onto the next slide, I want to reiterate that shared work is different from what I put in quotes as regular unemployment. Regular unemployment comes in two forms, where there is a complete and total separation from the employer, a severance of some kind. a discharge, a voluntary leaving, a layoff, a furlough, a shutdown, something like that. It also concerns a partial unemployment where somebody's not working 100%. They are only working a few hours a week on a part-time basis with an employer. And those have, part-time employment has very special rules, which we are going to get to on slide number 13. But the important concept here is that regular unemployment is not the same as shared work unemployment. There are a bunch of differences that are important, but most people are probably concerning. If you were on the receiving end of unemployment, you'd want to know if shared work disadvantages you in any way in terms of the amount of unemployment. It does not. The calculation, the mathematical calculation to compute a claimant's unemployment rate is the same, regardless of whether you're filing for regular unemployment or for shared work. The math behind it is identical. You might be familiar with base periods that you go back 5 most recently completed calendar quarters, emphasis on recently completed, and you take the average of the 2 highest quarters, you add them together, and then you divide by 26, and you come out with a weekly benefit rate. It is the same for people who file for shared work and for people who file for regular unemployment. Regarding some more basics, on the next slide, we will see that instead of laying off or severing employment completely, like you do on regular employment, the employer does not lay off a segment of its workforce, does not completely lay them off. Rather, the employer elects to spread the layoff, if you will, over all of its employees or over a segment of it, an affected unit. And in that way, no one gets 100% separated, but everyone gets partially separated for some hours or some days a week. And it can be up to at least it can affect 2 people in a given unit. That's how small it can be. As the slide says, it's a completely voluntary program. The employees do not file for regular unemployment. This is different. The employers file what's called weekly certifications that trigger the payment of unemployment. The employees do not file themselves. And if they have been filing for regular unemployment, they need to stop filing. That's how separate and distinct these programs are. Continuing on with the basics, this program is administered by the Connecticut Labor Department. Again, it's a voluntary program. The employer chooses to participate in this. They need to apply and to obtain the approval of the Labor Department to participate in this program. I will say that in the past couple of years, how everybody has had their different experiences with the pandemic, and employers have had different experiences with unemployment, and same thing with employees. I have never seen a time where employers have been more interested in having their employees receive their full entitlement to unemployment as I witnessed, say, a year ago in the March, April, May timeframe. I think it was universally recognized that people were unable to work, that no one was working. The businesses were unable to provide employment if it was due to no fault of an employer or employees. And yet the number of phone calls that it may have received, the number of emails from employers saying, we have no work, but I want my people to get whatever it is that they're entitled to. How can they do that? And a shared work of vehicle, can you get them the most that they can get? I mean, that is highly unusual situation for unemployment. Usually it's much more contested than that, but everybody was on the same page, and it was unbelievable, and kind of heartwarming to see that through the spring and summer months. The shared work program has a few regulations. I've attached them as an appendix 1 to this PowerPoint. The regulations are very easy to understand. Everything about this program is informal and flexible, and in this climate, the idea is to be as flexible as possible and try to include as many employers as want to be included in this program. The volume of employers has increased 7-fold. It's well over 1,400 employers that are participating in this. The federal government is trying to give grant money to the states to expand their programs. And it just seems that this was not a good program, that not this many people would be participating in it, and not this much money would be influxing into it as is. So I just want to reiterate that it's a very informal process, and the application is easy. It's a 3-page application, has about 23 or 24 questions. I've attached it as appendix 2 onto this PowerPoint, and we will go over a few of the more problematic questions that people get confused on. But by and large, it's not confusing at all, and it is flexible. All right, so let me continue with some basics and what the typical example is. Typically, if there is a temporary downturn in business that doesn't necessitate a full layoff or a full termination of units or people, what can be done is, if it's more of a minor type of downturn, for example, here there's a 20% business downturn. An employer confronting the 20% business downturn has 2 alternatives. They can lay off 1/5 of their workforce entirely, 100%, 20% of its workforce can be laid off, or all employees can be retained and share in the 20% business downturn. What the employer would do would be to keep all the employees, but reduce the wages and the hours of all the employees or some segment of the employee population by, say, 20%. 20% is the easiest figure that we can use, because since this is based on a 40-hour week, 20% represents an 8-hour day or 1 day a week that the employee would be laid off. There is and the layoff was a bad term, would not be provided with hours and wages. But there is the leave aspect of this. If you've reduced certain employees by 20% by 1 day, that'd be 1 day leave in which they are not earning wages and would not be receiving hours of work. On that 5th day, that 1 day per week, they would receive 20% of their weekly benefit rate. Because they are not working 1 day or 20% of their work week, they get 20% of their weekly benefit rate. The net result, as you can see in the next slide, is that all employees would be retained, and 20% reduction would be achieved by the employer. If we could move to that next slide, it would show you that the employees would receive 4 full day of wages as they were accustomed to. They get 20% of their weekly benefit rate for day number 5 because they're not getting any wages on day number 5. And day number 5 represents a 20% reduction, so they get 20% of their weekly benefit rate. Best example is if somebody had a weekly benefit rate of $450. That kind of breaks down to $90 a day. 9 5s being 45, 450. 20% of that 450 is that $90. So they would get $90 of unemployment on that 5th day. Employees receive the 4 days of wages. They receive their $90, 20% of unemployment, and they receive a dependency allowance. That is in non-pandemic times, and that has been the way it has been since 1993. The website that I mentioned has a lot of information, like the next slide. It belabors exactly the number of hours that an employer can reduce employees in an affected unit. How many hours, what percentage. The sliding scale is that an employer can reduce employees in an affected unit between 10% and 60%. And all of that is listed here. It's based on a 40-hour week. You can see that it starts at 10%, and that's 4 hours, and goes all the way through to 60%, which is 24 hours. This, again, is on that website, along with other information, more than you will ever want to know, probably, at www.sharedworkct.com. Okay, we talk about the advantages of this program and whether we possibly are overselling it on this next slide. The typical advantages, and if anybody disagrees, please let me know. But the typical advantages for employers are that you keep the workforce that you've trained. You keep them attached in what's going to be viewed as a temporary decline of business in the event of an uptick in business. You've trained the people, you've provided them with a lot of resources, and you want to keep them attached to you. This allows you to do so. Now up to 2 years, it allows you to do that. And it increases morale on both sides of the equation in that it avoids a complete separation of employment. I'm sure everybody is aware currently, today, as we are having this seminar, that there's a current political issue about whether or not the amount of unemployment is preventing claimants, workers, from returning to work. I understand that argument, and we get it, and we sort of foresaw this with the amounts of unemployment and the federal supplements that were added. But my point here is that if you were to enroll in shared work, you may decrease the opportunity for your employees to become fully unemployed and fully attached to unemployment. If you only are downsizing them from 10 to 60%, they are staying attached to you. Can't overstate that enough. They are not filing for regular unemployment. They are not getting exposed to their complete 100% regular unemployment rate. They're only getting a portion of that. And therefore, they'll stay attached to you. And chances are, or you can at least increase your chances, that someone's not going to completely separate and not become two attached to their unemployment compensation check. A further advantage to employers on this, excuse me, is that the federal government is paying and reimbursing 100% of employer charges for any employee that is enrolled in the shared work program through September 4th of 2021. The advantages to the employees are virtually identical in terms of employee morale. They retain the job and financial security. They stay attached as well, which does have a big benefit to employees. They want to stay retained. Their health insurance and their retirement benefits are required by our regulations to be maintained. So they do not decrease, even though their hours and their wages decrease. We can talk about the regulations and their requirements on the next slide. The regulations impose certain requirements that are not flexible, but these are part of what you need to agree to in order to participate in the program. The employer can affect at least two permanent employees in a given unit. It applies to full and part-time employees. You must identify a specific unit. Again, it has to be 2 employees. The range of hours affected there's a decrease in wages and a decrease in hours of at least 10%, but not more than 60%. In the event that an employer needs to lay someone off at a range greater than 60%, at that point, you need to shift over to regular unemployment and have your employees file for regular unemployment. The program applies to exempt and non-exempt employees, and the only thing that is not available to is to subsidize seasonal employers during any off-season period. A few more fundamentals are that the fringe benefits, as on the next slide, there's a regulation that requires fringe benefits to continue unaffected. There's the Reg 31250-10 subsection D that requires, quote, fringe benefits will continue as though normal weekly hours of work had not been reduced. This provides the fringe benefits to the employees in the hope that this temporary downturn in business will be overcome and be back to regular hours and everything as soon as possible. Seniority credits, they need to accrue at a rate at least commensurate with the amount of reduced hours actually worked. Some additional nuances are on the next slide that, as I've said, there are differences between participating in shared work and regular unemployment. For regular unemployment, remember now, in regular unemployment, you have severed from the employer. So as a condition of eligibility for unemployment benefits, the employee, the claimant, needs to be making reasonable efforts to find work in terms of searching with like at least a minimum of 3 employee errors per week. And you need to be available to work your normal hours of employment with an employer who might be willing to hire you. These regular unemployment concepts do not apply to shared work. Understandably, you're attached to your shared work participating employer. Therefore, you shouldn't be required, and you're not required as a claimant, to be looking for work at other employers. The program is not trying to have you leave the current employer. It's trying to keep you there, and that you don't have to be available for work for other employers. There is an availability requirement, but it's minimal. All an employee has to do is be available to resume the normal work hours, the increased work hours with the participating employer in the event that business hours return to normal. You had a temporary decline in business. You went from 40 to 32. If the employer resumes back to 40, the employee must be willing to accept those hours. Another significant difference, and I'm gonna belabor this over the next course of these slides, is that for regular unemployment, there's a way of filing for partial unemployment benefits. And if you file for partial unemployment benefits, what we do is, and I'll go through it, is you deduct some of those wages that you earn during the week from your weekly benefit rate. None of this applies to shared work. In shared work, if you moonlight, if you have another job besides the one with your participating employer, those wages are disregarded. Those wages are not used in any way to deduct from your percentage of unemployment. For example, if you were receiving 20% unemployment and you moonlighted at Home Depot or Lowe's, the income you receive from Home Depot or Lowe's is not subtracted from your 20% unemployment that you receive for that Friday. So it's not the same as partial unemployment. And to further that and to hit that home, I'm going to explain briefly how partial unemployment works. There's a statute, 31-229. And if you already know this, I apologize. I'm just trying to make it clear. And 31-229 says that whatever wages you receive during the week, they're not going to be deducted dollar for dollar from your unemployment rate. But what is going to be deducted is 2/3 of those wages. So in this example on the slide, let's say the claimant has a weekly benefit rate of $450 based on all their base periods and things. They're getting $450 per week. But because they're partially employed, they earn $300 in part-time work. Under 31-229, you take 2/3 of the $300 or $200 and you subtract that from the $450. Again, it's not a dollar for dollar thing. It's not $300 from $450. It's 2/3 of the $300. So it's $200. And that leaves you a weekly benefit rate of $250. Again, none of this applies to shared work. And the significance of that is on the next slide. Because you don't do a deduction, a 2/3 reduction, it works out a bit better for the shared work claimant. As you may know, during the height of the pandemic, USDOL added some additional weekly amounts, some supplements on top of your weekly benefit rate. There was, under the CARES Act, a federal pandemic unemployment compensation amount, we call it FPUC amount, of $600, and a lost wage assistance program added $300 separately at separate times during the pandemic, which meant that if someone were filing for unemployment at the rate of $450 in our previous example, they would get $600 on top of that, over $1,000 per week for unemployment for as long as the FPUC was in existence. Or they'd get an additional $300. That would be $750 per week for the lost wage assistance. Now, the thing about this with partials is that the the partially filing regular unemployment person would only get those extra amounts if after that mathematical calculation, they had at least $1 of unemployment payable to them. I'm going to go over this more in this next slide. So we've talked about the unemployment person who, the partially filing unemployment person who had $450 of a benefit rate, had $300 in wages. We took 2/3 of that, which was $200. We subtracted that from the $250, and that person was left with $250 of unemployment. Okay, so that person then would have qualified for the $600 FPOC or the $300 LWA on top of that. However, and believe me, this is just a long way of trying to get to a point, but what if the person had earned $900 in partial earnings? So the example being they still had $450 as their weekly benefit rate, but they'd earned $900 in partial earnings instead of $300. You do the same 31 to 29 calculation, which is take 2/3 of $900, which is $600, and you subtract that from their weekly benefit rate. 450 minus 600 leaves you a negative amount. The person doesn't have at least $1 for a weekly benefit rate. Therefore, this person filing for partials under regular unemployment cannot get anything added onto his amount or her amount for that week. No $600 FPOC and no $300 LWA. They get nothing for that week. Shift to the next slide, and for the shared work person, huge advantage to shared work. Because the person that receives shared work or is in a shared work program is receiving between 10 and 60% of their unemployment, they never are in danger of having a negative amount, of falling below zero in unemployment. They don't have to do that 2/3 calculation. So they can never fall into a negative balance. So the shared work person is always eligible for any full federal entitlements when they are applicable. And again, I'll reiterate that during the highlight of this pandemic, employers were very desirous of their employees getting each and every dollar of every benefit that was available to them, as they should be and as the employer should have been. So because the shared work person doesn't have to do that 2/3 calculation, they never get into a negative balance. They're always between 10 and 60%. They're always going to receive at least $1 of unemployment. They're always going to be eligible for the full federal entitlements. Shifting on to a few more nuances. There are really no wage and hour implications or disadvantages to participating in the shared work program. As I've mentioned, shared work applies to exempt and non-exempt employees alike. Non-exempt employees just get paid for the exact number of hours in which they work. They are hourly people. Exempt employees have exempt type management duties that are of an executive, administrative, or professional type. Plus, they get paid on a salary basis, the same salary, regardless of the number of hours that they work, whether they work 30 hours or 65 hours, same salary each week. And that's a staple of the wage and hour law. It has come to be asked that what happens, well, one of the requirements is that salary basis for the exempt employee must remain constant in order for an employer to take advantage of the exemption, not having to pay overtime after 40 hours, pay the same salary for any time after 40. And if you change that salary too much, there is a risk of that exemption being destroyed and the employee bringing a wage action against the employer seeking overtime because they claim that they really were treated as an hourly employee because the employer changed their salary so often. It really was like being an hourly employee. Well, in the shared work program, you can change the percentages that somebody of their wages between 10% and 60%. Accordingly, you can change salary in terms of those percentages as well. And you can do so more frequently than would be normally allowed by wage and hour outside of this program. And the reason is that it's contained on the next slide, that the fluctuations are permitted by a statute, a wage statute. 3171E, subdivision 1, allows an employer to make deductions in wages or changes in salary or amounts if they are empowered to do so by state or federal law. We interpret the shared work statute 31274 as authority that permits an employer to make a deduction or changes in salary within the ranges of 10 to 60%. So that becomes a statutory basis to allow the employer to make changes in salary. And thus, I believe will be on the next slide, that there is that the exemption will not be destroyed by participating in shared work. Employers also ask about PTO time, like what happens if an employee uses their accrued personal vacation, holiday, or sick time. That's perfectly acceptable. Employees can use all that time while they're on a shared work plan, provided that they work at least one day and get wages for one day during the shared work week. If an employee were to take all PTO time, all 5 days for vacation or whatever, for accrued holiday time or whatever accrued PTO time would be available, they would not participate in a shared work program or receive any payments for that week. The next slide concerns the application process. And I'm nearing the end of our presentation. I know everybody has their pandemic horror stories, war stories, or whatever. I just want you, just imagine the state, and imagine state computer systems, imagine the labor department. And I am not a computer guy. I am not by any means a computer guy. But imagine a state agency being dependent on COBOL computer systems to process unemployment claims. Not that that was ever the most desirable way, and I don't even know what COBOL is, but I think I remember in college, whatever that is, 45 years ago, people talking about cobalt. And that's what the Labor Department was using at the outset of this pandemic. And shared work is just a small part of unemployment and of regular unemployment. The unemployment system received 4 years volume of claims. 4 years volume in the initial 3 months of the pandemic. I have no idea how this COBOL system withstood that. I know we had our bumps, and I know we were unable to answer phones to the satisfaction of the public, but I just can't imagine anybody being able to tolerate 4 years worth of work in 3 months with no notice. It just is mind-boggling. But that's how dramatic it is. And hopefully we are by that time. In terms of shared work, the number of applications, which at a high was 230 a year, has jumped to over 1,400 a year. I know it doesn't maybe sound much, but this is a manual process. That is difficult. That takes a lot of bodies to process these things. We are seeking grants and hope to get grants from the federal government for automated processes to be able to automate this shared work and to expedite it and make it much more efficient to employers. The biggest drawback we have now is that the communication, we have trouble doing it one-on-one over a phone. There's just too many people to speak to. Again, we have a 3-page application for this process. It's easy, it's flexible, it's listed in Appendix 2. Like unemployment plans, you submit a plan, they all take effect, they all begin on a Sunday. The quickest means of communicating with our shared work unit. We do not have the phone capability. So if you can, use the email, which is listed there, dol.sharedwork@ct.gov. That's dol.sharedwork@ct.gov. Or use the old fax, 860-263-6681. 860-263-6681. Couple of things about the application that I will go over on the next page. These are the ones that people may have slight problems with, but they really aren't hard. And if you have to, if you're stuck, you can contact or you can do your best and answer it, guess, submit something, get it in, and somebody will get back to you. But the questions are, these are the problematic ones. There's a question 14, which I'll read to you. And it says, do you certify that you have paid all contributions for all past and current contribution periods as required under statute section 31225A? In other words, are you current with your unemployment taxes? It used to be a requirement, and it will be a requirement that you need to be current with your unemployment taxes, but that was partially waived during the pandemic period. You need to understand how the great emphasis during the pandemic was to get anybody who even had a whiff of wanting to participate in shared work, to get them into the fold, as quick as possible, and to have everybody take advantage of these of this program and the advantages of the program. The other question is number 17, which says, do you certify the implementation of a shared work plan and the corresponding reduction in hours are in lieu of layoffs that would affect at least 10% of all employees? What you need to do is estimate that. The answer to that needs to be yes, you're doing this to prevent layoffs. It's a temporary downturn. You don't know how long it's going to be. So you're trying shared work first. How many people would you lay off if you didn't have this program? Like, do the math based on the percentages and put down a number. Question 22 asks, are any employees who will participate in this plan covered by a collective bargaining unit? In other words, is there a union involved? If so, the application has a notice provision to the union. Contact them, obtain their approval. Lastly, the question is about notice to your employees. If there's no union, question number 23, if there's no union, it says, if your employees are not covered by a collective bargaining agreement, do you certify that a written copy of the proposed plan or a summary thereof has been made available to each employee in the affected group for inspection and comment for a period of at least 7 days. Have you had a comment period, and have you told the employees about your intention to enter into this program? There is a form attached as Appendix 3 on how you can provide the notice to your employees. Do not wait 7 days to submit your application. Send in your application right away by fax or email, and then notify your employees and get their sign off over the course of the next 7 days. And when that is all complete, fax or email that in to us, and we will match that approval by the employees with the application, and there you have not lost 7 days. And this was critical at the beginning of the pandemic. And my final slide is concerning renewals. Everything's been different in a pandemic. We used to provide shared work for like 6-month periods, maybe with a single extension or a renewal. The pandemic now is in its 2nd year. We now provide extensions for up to 2 years. They are in 6-month increments. There is a form that I've attached as Appendix 4 to this outline, and that's not only there, but it again is on that website, which I cannot tell you has so much information. It has more than enough than you'll ever want, and the best things are the forms. And again, that is www.sharedworks.com. It's got a lot of Q&As, just about every permutation you would think of, sample forms, and information of that kind. I thank you for your time this morning. I'd be willing to take any questions that there are, if anybody has them. Thanks.
All right, Steve, thanks. You know, I had a list of questions and you hit every single one of them. So thank you for that. I know just from experience from talking to our members that the employers really do appreciate the shared work program. So thank you to you and your colleagues for all that you did there. I know that was an overwhelming amount of work there, and hopefully it'll decrease as we move forward. But thanks for your expertise, and we'll see you next time.
Thanks. Thank you very much. That's my pleasure.
And that is all that we have time for today. I hope that you found it helpful and informative, and that you won't hesitate to contact our speakers for more information if you have more questions. And of course, CBIA members can always contact me or my partner, Philip Montgomery, either directly or through the HR hotline. Please don't forget to fill out the survey at the bottom of your page. We really do pay attention to your feedback as we plan for future events. And I'll hope to see you all again, whether in person or virtually, at our next event. Until then, thanks for joining us and have a great afternoon.